My lord, in the index, there was some mistake, and because of that, my lord, perhaps they are not able to locate the file. So they will be in a difficulty.
Okay.
Can it come next week, my lord? Wednesday, my lord?
When do you want?
Wednesday, my lord.
Okay.
Because it is
Uh,
our mistake that, my lord, they could not locate the file.
As sought for by Mr. M.K. Churi, Learned Senior Counsel, appearing for the petitioners, leads the case on Wednesday.
2008.
Mr. R.R. Kosik, Learned Additional Public Prosecutor, for the respondent state who is in attendance, has agreed to the seat prayer.
Obliged, madam.
Madam, I beg to mention for listing of a criminal petition, my lord.
Motion.
No, my lord, hearing. First, my lord, hearing.
No hearing, you make an application before the registry.
So I pray for listing of the IL on the next week, any date.
Next week, my lord, I have item number 19, my lord.
19.
19, on behalf of the petitioner.
19.
Yes, my lord.
Yes.
Possibly this matter may be insert to us, my lord.
Okay.
Because we have got information that the petitioner has expired.
Okay.
So for confirmation, some time may be allowed, my lord.
Okay, get the information early. So put it on the next week. Okay, on the prayer of Mr.
Yes, sir.
Borvia Learned Counsel for the petitioner, Mr. S.R. Borvia Learned Counsel for the petitioner has submitted that the subject matter of the Rivian petition might have become infructuous, and in order to obtain his instructions, he sought listing of the case on next Friday.
22.
To his time maybe.
Huh?
We are
Okay.
trying to communicate with.
Listing of the case on so and so date. List the case accordingly. on such.
29.
My lord, I beg to mention for listing on criminal revision petition, my lord. This is order matter, my lord.
Give it to the court master.
My lord.
Beg to mention for item number 21, your lordship.
21.
May be passed over for the day, your lordship. We listed
Uh,
after 3
Mr.
weeks. R. Kumar, your lordship.
You are for petitioner.
For the petitioner, your lordship.
You have informed the other side.
Yes, I have informed.
Okay, on the prayer of Mr. R. Core Learned Counsel for the petitioner, which prayer is made with the consent of the Learned Counsel for the respondents. The case is passed over for the day.
May be listed after 3 weeks, your lordship.
Yes, it is adjourned for 3 weeks.
Obliged.
Please, Your Honor, beg to mention for IA listing of the next week, any date, my.
Give it to the court master.
Obliged, Your Honor.
To mention for listing IA criminal the next week.
Give it to the court master.
Maybe the lordship, I beg to mention for a listing of a criminal petition, lordship, any date next week.
Give it.
Next is your lordship, I beg to mention item number 18, lordship, on behalf of Mr. G. Talukdar. He is not well, lordship, today. Kindly matter next.
Very old case. Okay. Miss
Miss B. Goswami.
Hmm?
B. Goswami.
B. Goswami, Learned Counsel appearing for Mr. D. Talukdar. Learned Counsel for the petitioners has submitted that Mr. Talukdar is indisposed and has thus prayed for listing of the case after a week. Additional public procedure is present. In view of the ground cited, Commander Prayer Lord list the case after a week on a date to be by the office.
May I please, your lordship, item number 11 may be adjourned for the day.
11th. Okay. On the prayer of Mr.
A.S. Chaudhary.
A.
S. Chaudhary.
Chaudhary, Learned Counsel for the petitioner. The case is passed over for the day. The case is adjourned for the day. You have informed other side?
Lordship informed.
Huh?
Informed.
Okay, Rico. Much has submitted that consent has been taken from the Learned Counsel for the respondent to make the prayer.
May I please, your lordship, I'd like to mention criminal petition 940 of the 23, which has not been listed for long.
Give it to the court master.
Lordship, I pray for listing of a criminal petition, my lord, on any day next week, my lord.
On next week, I don't know. Let me give. He'll ration it.
Lordship, may I pray for listing of an IA the next week.
Detail he told you, Bhavani.
Daily list for motion, item 1.
Hey, কি কয় হেৰি to দিব চোন কিবা যে kettle Yes,
My lord,
Mr. Kaushik. There are other orders.
Yes, my lord, but one thing, my lord, I don't know whether my learned friend has submitted or not, my lord. There are some orders which, my lord, I'm trying to find it out, my lord. I have not
Ah.
found till now. There, that it was not allowed, my lord.
It was not allowed.
It was not allowed. And perhaps, my lord, there is one order, if I am not wrong, of Honorable Justice, my lord, A.D. Chaudhary, my lord.
I felicit.
Listen again.
There is there, and Honorable Justice, Mr. M.K. Kolita, he took note of section 11(5) of the Assam Cattle Preservation
Yes,
Act.
yes.
And thereafter relaxed the condition.
Yes, my lord, but there are other orders which has not relaxed the condition, my lord.
No, you are not showing it.
Yes, my lord.
I-
I'm trying.
I- Yes.
Yes. That is the minor part of the second FIR and also. My learned senior friend is assailing that minor.
Hmm?
My learned senior friend is assailing that minor. So second FIR.
There is an order of the magistrate, right?
Yes, there is an order of the magistrate, madam, that your lordship will find page, second paragraph of the second page of the order, this
It's 45,
Page
40, sorry, 52,
second page of the
Page
report also.
45.
52.
52. You said investigation was completed. Investigation has been completed in the first case.
Yes.
Where from it is?
Page 36, and that is the FIR. And I've made a statement, I think, right?
Page 36. No, that is the FIR.
FIR, yes.
Investigation is completed.
Page 68, your lordship will kindly see, I have carefully considered second paragraph,
68.
bail order.
68.
Bail order of one of the accused. I have carefully considered every aspect before me, and on careful perusal of the
Submitted.
case diary, it appears that in case so and so has submitted charge sheet under so and so. 12 persons have been granted bail. It's stated, na? On the same.
BNS.
Yes.
BNS concern.
Your lordship will kindly see where is the ingredients of section 303 and 106 against the petitioner. And who is the complainant?
BNS.
303 is committing theft.
CIPC concern. It is the same incident,
Same incident, my lord.
right?
Yes. Same
Then-
incident, only thing, my lord, first it's a general FIR, my lord. Now, my lord,
Right, but
they are made
first
primarily accused.
lodged on 7/1.
7,
It was registered.
registered.
Then after 3 days, it 10/1/2025.
Yeah.
The second FIR was lost,
Yeah.
but the incident is same,
Incident is same.
right?
Right.
In the meantime, reported
Yeah.
death of 20%,
20%,
whatever.
my-
So at best, it could be treated as a statement under 161.
was, yes,
It could have carried out,
yes,
but for the same incident,
yes,
you just, because by treating it as a larger conspiracy,
yes,
you try to bring out a distinction.
lots.
But
That is-
larger conspiracy thing has been properly explained in
Yeah.
Ramlal Narang.
Yes, ma'am. And
Where
also, my lord,
two artifacts post were seized,
lots,
produced before a CGM.
lots.
Then during a course, it was found out that it was an international conspiracy.
Yes,
Then the second
Yeah.
FIR
yes.
was
Otherwise, law
permissible.
settle that part.
permissible.
Law.
Otherwise,
Yes,
even if charge sheet is submitted,
Yeah.
treating this as a statement under section 161,
Yeah.
you can carry out further investigation,
Yes.
but not second case.
and in the page 68, my lord, it has also been stated, my lord, those search sheet has been filed. The IOS prayed for further investigation.
And
That is
they
there, my
can do it
yes,
in the first case,
yes,
but second case,
yes.
same incident.
Same incident.
3 kilo area, something rat hole mining.
Yes,
Unfortunate incident
and very
that does not, yes, unfortunate whoever is
Yes.
involved
involved.
should be punished and brought
Yes.
to book. But
Yes.
by registering a second FIR, see the condition of the informants,
Yes.
see the condition of the informants.
Informant. I have seen the report speaks. Yeah. And I'm just find out one judgment, man, where the second FIR is, my lord,
Permissible.
Permissible, man, that is, my lord. There,
Permissible.
my lord, TT Anthony to Babu Bhai, everything is discussed, my lord.
Huh.
Lord's may kindly, otherwise the law is settled, my lord.
Which part?
My lord,
Huh,
Lord's
these
may-
are,
Eight-
these, I think this has been referred to as a magistrate. Perhaps, see,
This is,
maybe,
I have not
see
seen my-
the order of the learned magistrate.
Lord's maybe, my lord, I have not seen.
Come to,
Yes, sir.
same thing. Come to page 59, I have read.
Yes, Lord's.
But larger conspiracy has to be
Yes, ma'am.
in the term of Ramlal or
Yes,
somewhere it
Right,
is
yes,
distinguished.
Only-
Ramlal Narang.
yes. That,
Just because you
yes,
make it larger conspiracy,
yes.
there has to be sufficient material.
Yes, yes, ma'am. In the sort of
And
from the,
under 173(8),
yes,
he can do so.
yes,
It is already there perhaps.
yes. What, my lord, this 8.4, paragraph 8.4 in Babu Bhai's, my lord, judgment, my lord.
8.4,
yeah.
what does it say?
It, my lord, otherwise it says, my lord, how the second FIR is maintainable, just only, my lord, last line, my lord, 8.4 paragraph, my lord.
Please.
It is in the, my lord, page 10, lordship. page 11.
Please read.
Your Lordship, in case in respect of the same incident, the accused in the first FIR comes forward with a different version or counterclaim, investigation of both the affairs has to be conducted.
Counter,
That-
cross case
that-
or larger conspiracy.
Larger conspiracy, that is what they are.
These are the two distinctions.
Yes, madam.
But
And
incident is same.
incident. Incident is,
And here it is not a cross version.
yes, madam. Yes.
Just because you treat it as a larger conspiracy without any material.
Yes. And your paragraph 9 is the, my lord, the
Prayer
guidelines.
for further investigation is already there.
Yes.
Let him exercise.
Paragraph 9, your lordship may kindly. This is
And
the, my lord,
which prayer?
paragraph 9, my lord, the guidelines after the discussions, my lord. Paragraph
Where?
9, my lord. They are my judgment, my lord.
Which judgment?
I have just.
Okay.
Yes, ma'am. Paragraph 9 is the, my lord, guidelines, my lord. That is one. Nine point one to 9.5, my lord. Yes, sir.
No, this is larger. This
Yeah.
is larger. Paragraph 10 is larger.
My lord. Paragraph,
It goes out of
yes. Yeah.
the first situation.
Only thing, my lord.
What is the first FIR?
Yes. First FIR, your lordship. Page 34, perhaps, 34.
Paragraph 3. Initially, only one was involved.
Yes.
Then, second FIR running into 30 pages, details of LA's conspiracy. Was a
Yeah.
part and records. Anything? Hard.
Only let the investigation, my lord. I am not saying that they are guilty, my lord. They may, I am not saying they are involved at this stage, my lord, because but let the investigation go on, my lord, at least for the.
It is that he has, at best, as Babu Bhai has held, it
Yeah.
could at best be a treatment that can be given under section 162 CRPC.
Yes.
Once the process of investigation
Yes.
has been set in motion, any further information
Yes.
regarding the same incident
Yes.
has to be treated under
Yes.
section 161
Yes. That is.
statement,
Yeah.
right?
Yes.
And they can carry out investigation. But again, recording
Yes.
if this is allowed,
Yes.
suppose, and for the same incident,
Yes.
number of FIRs will be filed.
Yes.
First is quashed, second
Yeah.
is filed, third is filed. That cannot be allowed.
Yes.
Part, Mr. B.D. Das. Senior counsel. Is still by D. Thousand. Learned counsel for law. Petitioners. And Mr. MP Gusami Learned,
Yes.
additional public prosecutor for the respond number 1, State of Assam. The criminal petition under section 528. What is 438 here? BNSS, what does it indicate? 438. Getting confused every day.
528.
Okay. Section, read with section 438 of the Bharatiya Nagarik Surakha Sanhita 2023
What is your question?
is preferred by the petitioners seeking quashing of a first information report lodged on 10/1/2025 and registered on 13/4/2025 as Omrangso Police Station, case number 08/2025 under sections 303 within bracket 2/106 within bracket 1 of Bharatiya Nyay Sanhita BNS, Bharatiya Nyaya Sanhita. And an order, so the petitioners have also sought setting aside, has also assailed an order dated 20/03/2025 passed by the Court of Planet Chief Judicial Magistrate Nima Hassau. In CRL Miss Case number 01/2025, arising out of Umrangso Police Station, case number 08/2024. Posta. Before adverting to the contentions raised on behalf of the petitioners, it is relevant to mention that an unfortunate the first affair incident, an unfortunate incident had occurred at 3 Kilo area in and around Omrangso on 6/1/2025. Poster. The case papers indicate that the said incident had occurred due to from activities of mining in that area, and the process adopted for mining was rat hole mining. Poster. The incident resulted in tragic loss of 20 number of persons who were engaged as laborers in the activities of illegal coal extraction from the well type pit and got trapped in the pit underwater. Post para. One senior manager, technical, from Messrs Assam Mineral Development Corporation Limited, a Government of Assam undertaking, lodged an FIR, lodged the first information report before FIR, on 6/1/2025 before the officer in charge Umrangso Police Station, stating inter alia about the incident, unfortunate incident which occurred on 6/1/2025, mentioned above. Poster. In the FIR, it was reported that the concerned area at Kalamati is approximately is at a distance of 1 kilometer approx from the AMDC's Gorompani coal mine block area. Poster. At a time of in the FIR, the informant had reported that a number of persons were trapped inside the well-type pit hole and underwater. Poster. The informant further reported that the type of mining which was being undertaken was very dangerous, and the activities were being undertaken without any kind of permission from the Directorate of Geology and Mining, Assam, or any other competent authority. Poster. The informant further requested the police authorities to undertake rescue operation to rescue the trapped laborers from the pit hole mine. Poster para. On receipt of the FIR, the officer in charge, Umrangso Police Station, registered it as Umrangso Police Station, case number 02/2025, under sections 3(5)(105), BNS, read with section 21(1), page 37, Mines and Minerals, Development and Regulation Act, 1957. Full stop. And investigation was carried out thereafter. Full stop. It is stated that during the course of investigation, a number of persons suspected to be involved in the activities of illegal rat hole mining were arrested. About 12. First off. Subsequently, those 12 arrested accused persons were allowed to go on bail on 27 to 2025. By orders dated 27 to 2025 and other subsequent orders. First off, it has further emerged that the IO, the investigating officer of the case, Umrangso Police Station case number 02/2025, after carrying out investigation, submitted a charge sheet under sections 105/303 within bracket 2/61 within bracket 2/3 within bracket 5 of the BNSS related with section 3, prevention of damages to public properties, PDPP Act. Full stop. It is however not known from the materials on record as to when the such charge sheet has been submitted and who has have been charge sheeted. Full stop. Para. The genesis of the present list is another first FIR lodged by two informants within bracket the respondent number 2 and the respondent number 3 before the officer in charge, Umrangso Police Station on 10/1/2025. Post up. In the FIR, the informants referring to the incident which occurred at in and around 3 kilo area of Umrangso on 6/1/2025 due to allegedly carried out rat hole mining activities. Post up. The informants have stated that in the said incident which resulted in the tragic loss of 20 lives. The incident resulted in tragic loss of 20 lives due to illegal rat hole coal mining, which has been declared as illegal. Full stop. The informants, purportedly basing on credible information and documentary evidence, have alleged that the petitioner number 1, who is the wife of the petitioner number 2, the present Chief Executive Member, CEM of Dima Hasa Autonomous Council, was directly involved in the allegedly illegal rat hole coal mining activities at 3 Kilo area, coastal Para. It has been projected on behalf of the petitioners that the petition number 1 is only an approved licensee by virtue of a deed of agreement dated 22/07/2020, executed with the Assam AMDC Limited. And as per the license, the petition number 1 can only store, sell and trade coal. Besides, and also can procure coal from open markets. It is further contended that the petition number 2 has been implicated in the affair without any kind of credible materials. It is further contended that the FIR lodged on 10/1/2025 is with regard to the same incident which occurred on 6/1/2025. Post of Para. Mr. Goswami, Mr. Dalit, it is contended by Mr. Dalit, additional public prosecutor, that the FIR lodged on 10/1/2025 has been registered pursuant to an order dated 20/03/2025 passed by the Chief Judicial Magistrate Dima Hasa Haflong, when on after the informants preferred an application under section 175 within bracket 3B and SS. Full stop. Upon consideration, the learned magistrate had found that the contents of the FIR lodged on 10/1/2025 is indicative of a larger conspiracy. Full stop. Para. The matter would require further consideration. Issue notice returnable on so and so date. The petitioner, as Mr. Goswami has appeared, accepted. Response number 1, extra copy. The petitioner shall take steps for service of notice on the response number 2 and the response number 3 by registered post with AD. Full stop. Para. On the when the petition was moved on 31/7/2025, comma, an additional public prosecutor was requested to obtain a status report of investigation pertaining to Umrangso Police Station case number. Next case is what? Case number? Over the Kiribati, second FIR registered is, it was pursuant to the order dated 23/2025 passed by the so and so. The FIR lodged on so and so has been registered as Umrangso Police Station case number 2000 so and so under section
303 subsection 2 106 subsection 1.
BNS. Full stop. A status report has been placed. It is a status report from the IO of the case and additional superintendent of police crime, Dima Hassau Haflong, addressed to the public prosecutor, comma, has been placed before the court. Post up. In the report, comma, it is mentioned that both the affairs are with regard to the same incident, but the second affair has indicated about a larger conspiracy. Full stop. The information provided by the two informants are mentioned. Full stop. Paragraph. Admittedly, comma, both the affairs registered as Umrangso Police Station case number 02/2025 and Umrangso Police Station case number 8 of 2025 are about the same incident, same unfortunate incident which occurred on 6/1/2025 in and around 3 kilo area of Umrangso. Full stop. The FIR lodged in connection with Umrangso Police Station case number 02/2025 had set the machinery of criminal prosecution in motion, and investigation was commenced thereafter. Full stop. It has emerged. No, it can be found out from, it is stated at the bar that after completing investigation into the case Umrangso Police Station case number 02/2025, the IO has already submitted a charge sheet and also sought made a prayer to carry out further investigation of the case, comma, which is permissible under section 173 within bracket 8 CRPC. Full stop. What will be the new one? It's BNSS, I'm sorry. What is that 173 is equivalent to? Mm, 193. 193. Within bracket 9. 9.
Nice.
The law is otherwise settled.
After placing one judgment, but after placing.
That in respect of one particular incident of crime, there can be registration of one case, comma, unless the unless any other FIR projects a different version or a larger conspiracy. Full stop. It is the proposition that on completion of investigation and on the basis of the evidence collected, comma, the IO of the case has to form an opinion under section 169 or 170. Now, what will be this one? Please tell me 169 equivalent in BNSS and 170 from the table. This is very difficult. This BNSS and CRP is very difficult. Uh, 189 or 190 BNSS within bracket earlier, comma, section 169
169.
or section 170, comma, CRPC. As the case may be, and forward his report to the magistrate concerned under section 193 within bracket 2 BNSS within bracket earlier section 173 2 CRPC.
Yes.
First up. However, even after filing of such a report, comma, if the IO comes into possession of further information or material, comma, he is not required to register a fresh FIR as he is empowered to make further investigation, comma, normally with the leave of the court, comma, and where during further investigation he collects further evidence, comma, oral or documentary, comma, he can forward the same with one or more reports which are ordinarily called as supplementary charge sheet. Under section 193 within bracket 9 BNSS within bracket earlier section 173 8 CRPC. Post of in the case in hand, Commander Ayo has already made a prayer for further investigation. Post of. Apparently, the FIR lodged on 10/1/2025 is a second affair in respect of the same incident. Post of. It is in T. Anthony from the propositions laid down in T. Anthony and Babu Bhai, it can be noticed that if after registration of the FIR and so or submission of the report any further information is given to the officer in charge of a police station in respect of the same incident, the officer in charge is not required to enter register such information as is not required to treat the same as an FIR. Second FIR in respect of the same incident, as all other information given orally or in writing after the commencement of the investigation into the same incident can be treated as statements falling under section 162 CRPC. Now, 162 CRPC.
Now 180 to
In view of
180,
in view of the
181.
facts emerging from the materials from record and the settled proposition of law, this court is of the considered view that
180.
the petitioners have made out a prima facie case for interim relief. It is a 180.
No.
It is reported that ordered in the interim that the criminal prosecution instituted in connection with Omrangso Police Station case number 08/2025 shall remain state till the returnable date. Let the informant come.
Item 4, 10 September, your lordship. And item 4.
Lordship, kindly pass over for time being.
I don't know whether I can come back or not. At 1 will be rising.
Item 5.
May it please your lordship.
Yes.
My lord, here in this case, lordship, an FIR was registered against the petitioner's lordship as Silchar PS case number 1984, lordship, 2023.
Where is the FIR?
FIR lordship at page, lordship, that starts from page 11, lordship. And,
Page 11.
Page 11. is the form,
Petitioner
lordship.
name is what?
14 is the lordship main.
Sahid Lily Tohit. Okay.
Thereafter, lordship, the learned court below, lordship, granted bail to the petition number 1 and 2, and petition number 3 preferred an anticipatory bail application before this honorable court, lordship. And during-
Granted bail, arrested Anybody arrested?
Not arrested, Lordship.
Okay.
So thereafter, Lordship, while the said anticipatory bail application is pending, Lordship, the respondent number 2 filed an affidavit before this honorable court negating the entire story of the FIR, Lordship. And accordingly, this honorable court granted bail, holding that there are no incriminating matters, nothing else, Lordship.
What kind of allegation is this?
That earlier registered.
Okay, well, you should notice at this stage.
Yes,
My
But it is a minor girl involved.
No, my lord, as per
Minor girl.
charge sheet, Lordship, she is above 18, Lordship. In the charge sheet that was held, Lordship, she is above 18. Even then, your Lordship may kindly see, Lordship.
Who has lodged who has filed a affidavit?
FIR was filed by the mother, Lordship, mother of the
Mother.
victim girl, Lordship.
But victim is not there.
Victim statement was recorded, Lordship, and that was already held by this honorable court, Lordship. Your Lordship may kindly see page 22, Lordship.
See, for consideration of bail is different, for passing is different.
Yeah.
Now tell me, where is that?
Lordship, your Lordship may kindly, my lord, page 22, Lordship.
And why for page 44, Mr. Borwinger? Page 44. As the victim is minor, why it is mentioned?
My lord.
Please
Yes.
answer me, page 44.
The order is. The next date is on 8th of October.
Heard Mr. M. Biswas. Not in counsel for the petitioner.
Proclamation
And-
also executed, my
Will go and appear in the.
proclamation also executed, page 18, my lord.
This is illegal. Cannot at the same time.
Yes. And we
It
develop,
is vulnerable.
yes. and-
And Mr. R. Kosik Learned, additional public prosecutor for the respondent. State, full stop. The instant criminal petition under section 528 BNSS is preferred to assail. Two orders, comma dated 21/10/2024 and dated 23/5/2025, comma passed by the Court of Learned Additional Chief Judicial Magistrate Kachar Silchar, Trial Court, in Police Report Case PRC number 675-2023, whereby the trial court has ordered for issuance of non-bailable warrant of arrest and proclamation and attachment against the petitioner to secure the appearance of the petitioner before it. Full stop. Para. The first information report was lodged before the officer in charge, Dholai Police Station, Dholai, Kachar, on 15/5/2018 against the petitioner, stating inter alia that the petitioner giving a promise to marry, comma, lived together with the informant for a period of more than 1 year. And during the period of living together, comma, the informant became pregnant and the pregnancy was aborted. Full stop. on receipt of the FIR, comma, a case, comma, Volai Police Station case number 113/2018 was registered for offences under sections 120B, 376, 493, 313 of the Indian Penal Code. On 15/5/2018. Post of investigation ensued thereafter. And after completion of investigation, comma, the IO of the case submitted a charge sheet under section 173 to CRPC by charge sheet number 123 on 31/7/2022, finding a privacy. So finding sufficiently, finding a privacy case for the offences under section 120B, 376, 493, 313 CRPC.
IPC.
Oh, IPC. Full stop. The IO in the charge sheet had reported that the petition was found to be absconding and avoiding police arrest. Full stop. On submission of the charge sheet, PRC number 675/2023 has been registered and was transferred to the Court of Additional Chief Judicial Magistrate, Kacha Silchar Trial Court for disposal. Also. From the order dated 21/10/2024, comma, it can be noticed that at an earlier point of time, the trial court, to secure the appearance of the petitioner, comma, ordered for issuance of bailable warrant of arrest. Full stop. A report was placed on 21/10/2024 to the effect that the VWA could not be executed as the petition was not available at the given address and was staying at Guwahati. Full stop. The trial court, forming an opinion that the petitioner was trying to avoid the process of the court, ordered for issuance of non-bailable warrant of arrest and proclamation and attachment against the petitioner, fixing the next date on 4/1/2025 for his appearance. Full stop. On subsequent dates, I don't know, nothing is there in between.
Probably there was no effective order.
You choose your own, not to annex.
Order.
As per from the order dated 23/5/2025, comma, it can be noticed that the proclamation and attachment order issued against the petitioner returned with a report that the proclamation order was hanged in a public place for wide publicity. Full stop. The order of attachment could not be executed as the EU did not find any movable or immovable property in the name of the accused petitioner. Full stop. The court, taking note of the same, comma, the court has ordered for appearance of the EU on the on 12/8/2018, which is the next date of the proceedings of fixed by the file court for the proceedings of PRC number 675/2025.
But on
12/8/2025.
on 12, the presiding judge was on leave and the next date is 8
Yes.
October.
Submitted that on 12/8/2025. The presiding officer was on leave and the next date of the case is
8 October.
8 October, 8/10/2025. First of para. From the order dated 21/10/2024. It can be noticed that the BWA was returned with a report that the petitioner was staying at Guwahati post office. There is post para analysis. As per the provisions contained in subsection 1 of section 84 of the BNSS, if any court has reason to believe that any person against whom a warrant has been issued by it has absconded or is concealing himself so that such warrant cannot be executed, the court can order for publication of a written proclamation requiring him to appear at a specified place and a specified time not less than 30 days from the date of publication of such proclamation. Poster. A reading of the said provision indicates that before issuance of publication of a proclamation, the condition precedent is issuance of non-bailable warrant of arrest. Close up. And only after the court reaches has a reason to believe that any person against whom the warrant has been issued by it has absconded or is concealing himself, the court can issue order for issuance of publication of proclamation. Post of, in other words, the order for a proclamation cannot be issued at a time before passing an order for issuance of non-bailable warrant of arrest at an earlier point of time. Post of primacy, the order dated 21/10/2024 appears to be vulnerable. Full stop. If the foundation falls, the structure falls. Full stop. Para. Be that it is me. Full stop. The petitioner has approached this court by stating that he is ready and willing to participate in the further proceedings of PRC number 675/2023. First up, it is an apprehension of the petitioner that before his appearance before the trial court on his own on the next date, 8
October.
in 2025, he might be taken into custody in execution of the NBWA issued against him. First of, it is here the petitioner has undertaken that after appearance before the trial court on so and so, there will not be any further default in his appearance. First of, having regard to the fact that and expeditious conclusion of the proceedings of PRC number so and so is in the interest of all the stakeholders, be it the prosecution, the witnesses, and the accused. First of, in view of the undertaking given by the accused that he would appear on so and so date, this court is of the constant view that to facilitate his such appearance, along with the undertaking, the NBWS issued against the petitioner can be kept in abeyance till 8/10/2025. First of, it is therefore ordered that the petitioner shall appear before the trial court on so and so, and till then, NBWS issued against him shall be kept in abeyance. First of, if upon such appearance the petitioner prefers any application for bail, the trial court shall consider the same on its own merits and in accordance with law.
My lord, the issue is that because it is still at the pre-committal stage. Now, my lord, the warrant is issued by the Chief Judicial Magistrate, and the section 376 is a session trial. So normally, my lord, what they do is that this is the real apprehension. When we go and file a bail application before a magistrate, the magistrate often says
It is punishable up to
376 is, my lord, 10 years and above. Session trial.
370. It is charge sheet is under what?
Charge sheet under 376 is there.
Huh?
376.
Then you prefer a bail application then.
My lord, after someone has been issued anticipated bail, probably would be maintainable.
That is the law. If PNA is issued, that is the law.
Yes.
And anticipated bail is not
maintainable.
law. And similarly, we can, what is the provision for NBWA?
80, the previous provision, I got to take it, 80.
NBWA, only the court which has issued it can recall it or
Absolutely.
cancel it.
Absolutely.
We don't.
Absolutely.
We also don't have the discretion.
My lord, my lord, this is a gray area which is happening, my lord. What happens?
Happening everywhere.
That once in a case which is triable by session, before pre-committal stage, the moment we go and appear, invariably the order is, this is a session tribal case, we will keep our hands off. You go to jail,
What is the punishment?
punishment, my lord.
76.
Lifer, I think,
Let us
376.
see. Once again.
10 years.
I am thinking, IPC, I'm thinking.
This BNS and IPC at times it is.
Oh, I am having a hell of a time to compare the provisions.
Yes.
In this case, charges are under 61 and 103.
61 is
61 is criminal conspiracy, 103 is murder. Lord.
murder.
Yes. I've been granted bail on 23/12/24. Security amount is of bail amount is of 20,000.
This has not been listed.
This is fixed on 18th. Lord.
18.
Yes.
Okay.
The same district, so perhaps it may come up.
You do one thing. 6, 7, 8 are same,
Yes.
right? 10 is also same. So you carry out the correction in paragraph 2 and 3 and 4, 5 by pencil. Right?
Yes. Good.
We can know. Government advocate is there.
My lord, their presence is required perhaps, my lord.
He is already there. ZA. Earlier Green Pig was there.
Yes.
G Pegu, name of G Pegu to reflect koi dibo. You serve a copy to G Pegu also likhi dibo. Push. Here 6, 7, 8, 9. Aru 10, 11, 12. Ekin thike thakibo. Next date of the case, some time is to be given. 26 month idiot. 13 no eki thakibo. Legal Service Authority District. Morigaon. You change the particulars in paragraph 2, 3, 4, 5.
Please.
26, 8. And inform Mr. Pegu. Serve a copy to Pegu also.
Okay.
Item 8.
Cattle, Bangarandi.
Yes, my lord.
Okay, who is there?
21st, my lord.
21st.
21st. Okay.
Same the item number 1.
Similar matter.
Same. Cattle, Bangarandi. And Borua, Planning Council Board petitioner, and Mr. R. Kosik, an additional public prosecutor. For the respondent state, it is submitted by the Council Board of parties that a similar, another criminal petition number, item number 1, involving similar issue, has been ordered for listing on 21st. And the Land Council Board of parties have sought listing of this case also on Swenson. This is the case accordingly on Swenson.
Item 9.
Please, your lordship. We are challenging the. Please, your lordship. We are challenging the executive magistrate order passed under 145 CRPC and 146.
Which
CRPC.
page?
Page 26. May I read?
On maintenance status.
CR put up today, both parties present and were heard. There is a issue.
Dropped.
Drop?
Case has been dropped.
No, my lords, further, the concerned police station may be instructed to attach the said DL, disputed lead, and maintain status quo. Now, your lordship, it was in our possession. There is a civil suit that is pending. Injunction was granted. Again, it was set aside in favor of the respondent. Now we are going to show the land. The police are not allowing us to show the land. The word that has been used is very loose. It allows for them to misinterpret.
Not by the present and heard, there is an issue with possession. There is a high chance of acceptance. Therefore, may be signed. Bond may be signed. Okay, we should notice at this stage.
No, my lords, we need stay because the season has started and we need to sow the land. And it's in our possession. And under 145 CRPC, there is no power of the executive magistrate to pass such orders. The law is well settled. If I may be allowed to let you, my lords, let you go to the law. There's also an order of division, coordinate bench.
Show me later on, what is your case?
So,
Because you run the risk of the declination of interim prayer also.
I'm sorry, my lords.
Right? If I hear you, if I am not satisfied, I'll decline the prayer, rejecting the interim prayer. Right? You run the risk.
I have, because I think I have a good case.
I don't know. I don't know. I have not applied my mind. But you run the risk.
Will try my luck, my lords. So, my lords, in this case, respondent number 2 and 3, they are the
Who are respondents?
respondent number 1 is the state of Assam. Respondent number 2 and 3, my lords. Respondent number, so all the petitioners are siblings. Respondent number 2 is the sister-in-law, and respondent number 3 is the nephew, our nephew, man. What happened is after the entire suit property is ancestral land. All of us are co-pattadas. After the death of Samsul Hussain, that is our brother, respondent number 2 and respondent number 3, they claim the entire land. Accordingly, so they filed a suit. The title
Where is
suit-
your suit?
The title suit, it is at page 42 minutes. That's the plain. That is still pending. Now, in the suit, let's make I
Where
read
they?
to page 62.
Who are they? You are 3 defendants. And who are the other defendants?
We are all siblings, minutes.
No. Page 42.
Page 42.
1 to 3.
Hmm.
The petitioners. Who are the others?
Yeah,
4.
they have
Who is 4?
performer difference.
It is not shown as performer. 4 is not performer.
Who is my sister.
Okay, what is the
The prayer is at page.
suit about?
The suit is the prayers is at page 60 minutes. They're asking for the property to declare plaintiff as the exclusive right interest over suit property, Schedule A, Schedule E. Land.
Schedule?
A and Schedule E land. Now, our concern is with only with respect to Schedule E, which is we have assailed in the order of the executive magistrate. Page 59 minutes. A degree of recovery of khas possession of evicting all prayers C carried out by the defendants over the Schedule E land, also by restraining them from doing any activity over the suit land. Page 60, they're all permanent injunction also they've asked for.
May come to page 57.
Yes, madam.
T.
57.
Yes.
T.
T.
Yes.
They are saying they are still in possession of Schedule A land. The opposite party is threatening to dispose the petitioner from Schedule A land and Schedule E land. Moreover, the Schedule E land of the plaintiff is in danger. If the opposite party is not restrained from trespassing into the scheduled land by disposing the opposite party therefrom, the petitioner will face plaintiff, whatever language. Then what is a prayer?
Page 61 and 60, madam. Starting from 59.
There is confirmation of possession, Schedule E and Schedule E.
We have filed,
And what is the orders pass?
we have filed a written statement, my lord.
You file written statement.
Yeah.
Any,
That is at.
I moved. Order 39 moved.
Yes, sir.
Where is your written statement?
Written statement is at page 101.
1 minute. After the print, what are? Okay, Ms. J case number 66. This is under order 39. This IA is for what? Order 39.
In this case, my lord, that is for injunction.
Order 39.
Yes.
We have noticed expert interim injunction. Schedule A and Schedule E. What is the order passed in this case?
In the injunction, they gave ex parte, they gave an injunction. They
Where is that?
granted in favor of the
Where is
respondent.
that?
Page 95. It was an ex parte. We challenged this.
Oh,
and
1 minute, let me find out. Ad interim injunction is granted against the opposite parties in respect of suit premises, still appearance of the Page 9, yes.
Now this was challenged and it was set
Written
aside.
statement,
Page 109.
109.
It's a quite long order. I'll just let you at page
Miss appeal.
139.
Appeal. It was an appeal
Yes, Your Lord.
against that order.
Yes. Page 139, my lord. I may read. The court, in consideration of observation made in foregoing point, found that passing any
Page,
restraint order against
page.
139 will surely cause irreparable loss to them, as the balance of convenience equally lies in their favor, similar to that of the petitioner in respect of the suit land, Schedule A and E land. Thus, it is found that the learned trial court was not proper in deciding the balance of convenience and irreparable loss solely in favor of the petitioner. Accordingly, the injunction order dated 13/10/2023 passed by learned court is set aside in this appeal. However, in the view of the observation made by this court while deciding the three golden principle of injunction, the court is of that all the parties shall maintain status quo in respect of the schedule land A and E till land till disposal of the main suit. After this remedy has been exhausted, my lords, they go and file a non-FIR under 145, 146, read with under 107 CRPC. And in that order, the executive magistrate, they pass an order to attach the land, disputed land. Now, the land is in our possession. We are cultivating the land.
Where it is mentioned in the order, in the miss appeal?
I'm sorry, what is mentioned, my lords? That
Your position, where it is conclusive finding? Because the trial court has, appellate court has granted status quo.
granted status quo.
Yes. Where is the finding? Privacy finding in the order. It might have vacated the order, but it has granted status quo. Because at the same time, it has observed that the other parties should not be also prejudiced. No, we are into that appellate court order. Because equally lies in their favor. The appellate court has observed that equally lies in their favor, balance of convenience, irreparable loss. Equally.
I'm not making sound. Sound it.
So that is why status quo. So injunction has been modified to status quo, and it is equally lies in their favor.
The problem is, well, it's the status
No,
quo.
no, where is the clinching finding?
But that finding is the point of the trial, because my lords,
Right.
the possession itself is a disputed fact. They are claiming the
You
respondent.
are claiming, they are claiming, sir.
Yes, my lords. They are claiming that the
If
possession itself is a
the
disputed
appellate court
fact.
has recorded that balance of convenience and irreparable from the perspective of so-and-so equally lies for both the
But
parties.
your lordship is right on that.
Right.
here
So
the
where is the
status quo-
finding that something that you are in position?
Because
And
possession-
that
because
status quo has been done
it's
by the appellate court.
Yeah. Because here the possession itself is a disputed fact.
And this court
Yes,
has
yes.
also said status quo.
The status quo, but they have attached the disputed land. We are okay. We'll maintain the status quo. That's no dispute. But please just do not attach the disputed land. A, B, executive magistrate doesn't have the power. It's ultra virus. A, the order is ultra virus. Third, once the
What is ultra virus?
It's virus. It's
What
otherwise
is
it's out
ultra
of the. It's out of. It's illegal. Madam, in the way.
Use the word properly.
I apologize. Understand? It's illegal.
Where is, how it is illegal? He do not have the power. He does not have the power
Yes, madam.
to attach disputed land.
Yes, madam. Because under
Where?
one-
Which provision says?
Well, it's 145 of the CRPC.
Uh-huh.
It is in 164. BNSS.
Hmm.
This is judgment. Madam. Excuse me.
Don't throw judgments.
But there's just interpretation. Madam. I mean.
No, first
That's-
provision.
Okay. Page 164 BNSS, if I may be read.
Yes, which diverse him.
Yes, madam. Now here, whenever an executive magistrate is satisfied from a report of a police officer or upon the other information that a dispute likely to cause a breach of the peace exists concerning any land or water or boundaries thereof within his local jurisdiction, he shall make an order in writing stating the grounds of his being so satisfied and require the parties concerned in such dispute to attend his court in person or by an advocate or on a specified date and time, and to put in writing statement of the respective claims as respect to the fact of actual possession of the subject of dispute. Now, my lords, this provision has been, the breach of peace has been interpreted by the coordinate bench of this honorable court and the Supreme Court judgment. The breach of peace, the magistrate can only exercise this power when there is a breach of peace which can harm the public tranquility, where there is a possibility of a riot.
Sir, we are into motion. We are not deciding the case unless the other party comes.
Yes, ma'am. We are only
Right.
asking for a stay. So we are saying 145, the magistrate doesn't has a power. So that's why.
Where from are you saying does not have the power to attach the dispute land?
Yes, ma'am, it's there, it's settled. Please do. From para 15 minutes. They quote the entire 145 CRPC and then subsequently.
Which paragraph you are showing?
Para 14 minutes at page 18, 17. 18. In caution, Mr. Anand.
Okay, we'll hear you on another date too. I'll be rising at 1
Yes,
o'clock.
please
Other
give us
matters
stay
are there.
minutes.
Okay.
Please give us a stay minutes. Please give us a stay minutes.
Monday. Put it on Monday. We'll hear you exhaustively.
165 also there.
Mr.
TK Agarwal.
Agarwal, petitioner. State is a party, MP Guswami. List the case on Tuesday.
Item number 10.
This is quashing of FIR and charge sheet lordship and this case lordship the
Washing.
lordship.
Let us see your FIR.
FIR is will find page number 17 lordship.
You are
Come to lordship particular page number 25 lordship, very big long FIR lordship.
State of Assam, Amina Khatun, Suhail Ahmed.
Can come page number 25.
Suhail Ahmed. Page number 25.
25 particular lordship. Very long FIR lordship. But otherwise lordship, the victim girl at the time of occurrence lordship, she was measured. But the police lordship, this case is registered.
Transferred without informing me, although the petitioner was representing through an advocate to assist the public prosecutor. That was, that your lordship will find page 20, which was allowed.
Accused submitted the informant of this case has engaged to help the prosecution repeated petition for withdrawal of that. This one is 32.
Not this one, lordship. Page 20 is the lordship order whereby I was allowed to represent through a private counsel, lordship, to assist the public prosecutor. So my involvement is.
You are an accused or what?
I am the informant.
Informant.
So for assisting public prosecutor, that application was allowed. So I was representing. Now what happened, lordship will see page 29. This case was proceeding, lordship, on 2 dates, lordship. I have taken date as well as the public prosecutor for filing objection. That page 29 and 30 in an application, lordship, and
Page 29.
lordship.
Present accused. Current counsel for the accused file petition submitted written opposition against petition numbers on which is received. File petition numbers. What are these petitions?
That
First paragraph.
311 of the
461 is what petition?
that 311 petition I have filed, lordship, that because while
No. Line counsel for the accused file petition number 461. What is that?
that, lordship, initially I filed an application.
No, it is an accused. You were informant.
I am informed that application relating to that the application which I have filed under section 311. That was why I am referring to
311 for
I have
witness.
filed.
For witness.
Yes, but for recalling of witness. Because, lordship, that when I
No, you are agreed by which one? Please
that,
tell
your
me.
lordship, page 32. Page 32.
So praying for withdrawing the case record from this court.
Yes.
That part.
That part. Because, lordship, you will see page 31, the case was fixed on 3/5/25. I was under the impression that case will be taken up on 3/5/25.
What is your submission? What
My
is this?
submission is that the case was transferred without informing me, lordship. Because I was representing in that case, lordship, and by blaming that I am taking repeated adjournment,
Mr. Ahmed.
lordship.
see the BNSS or CRPC. Whether this court has the power to send back the case record, to send the case record to a higher forum to pass order on it. Right? Cases are transferred from up to down, not down to up. You make your submission on that point, sir. Go through the provisions. Then that court does not have the power to send the case record to the higher forum to pass an order on transfer.
That application has to be.
That you
under that-
structure on that basis. Otherwise,
Yes, that is under section 410, that has to be filed before the.
show me the provisions because
Earlier section.
earlier it is 409 perhaps.
410 is.
410.
Yes, CGL power.
That is the only
That
question.
is the.
Yes, you are appearing for.
May I please, my lord?
Yes,
I'm for the respondent number 2, my lord.
yes.
My lord, I was going to pray that can the matter be fixed on Monday, so that my senior Mr. SP Chaudhary can bring out his point. Due to certain water logging issue.
Okay,
Only
Tuesday.
that the matter is fixed on 16.
Then we'll dispose of.
No, they are filing repeated application for expeditious trial, Lordship, and for early disposal of that application.
Tuesday will be late.
Lordship, that 16 is on.
Huh?
Is fixed on 16, so that will be.
It is fixed on 16.
16, Saturday, it is fixed. So if it is goes to Monday, then on that day, Lordship, I may be allowed to take adjournment, Lordship.
Okay.
That observation will be there. Otherwise, that will be defeated,
Okay, we'll put a status quo.
Lordship.
My lord, if possible, can online proceeding be done today?
Huh?
If possible, my lord. I'm just placing, my lord, if online proceeding can be done today after rising of the division bench, so that whatever submission.
No, that is not permitted.
Monday.
Who is your senior?
Mr. SP Chaudhary, my lord.
Then I'll stay.
My lord, can I,
Heard, Mr. Yami. Council Porter. It is not in accordance with CRPs. Expressly apparent. I thought that I'll be running short of time. That is why I thought that I'll post it on Tuesday.
my lord, can it
Right,
be
so
after-
that I can pass a detailed order. Now I have to state.
My lord, if.
And Mr. MP. Goswami Land Additional Public Prosecutor for the respondent state. Full stop. Mr.
K. Vishwakarma, my lord.
K. Vishwakarma Land Council has submitted that he has instruction to appear on behalf of the respondent number 2. Full stop. The instant criminal petition. Under section 42528, BNSS is preferred to assail an order dated 23/4/2025. And a consequential order dated 24/4/2025. প্রথমটো দিব annexure 9, second to annexure 9 নেকি?
Just page 33.
এনেকে লিখক ব্ৰেকেটত at page number 32 and at page number 33, huh? By the order dated 23/4/2025. Comma, the Court of Land and Judicial Magistrate First Class Reviewer. As inter alia. Ordered to put up the case record of. This is what case? PRC or what?
Yes, PRC 1728.
PRC 1728/2021. Before the Honorable, before the learned Chief Judicial Magistrate Dibrugarh. As the learned counsel for the accused
Yes.
had made a prayer for withdrawal of the case record from the state court. Full stop. Pursuant to the order dated 23/4/2025, the Chief Judicial Magistrate Dibrugarh passed an order on 24/4/2025, whereby case record of PRC number 1728/2021 has been withdrawn from the Court of London, Judicial Magistrate First Class, Dibrugarh, and has ordered for transfer of the same to his own court for disposal. Full stop. Having regard to the provisions, issue notice returnable in so and so. As so and so has appeared accepted. Extra copy. Having regard to the provisions contained in section 410. What is new? BNS?
Probably 150. Just I'm giving. $450.
450.
Yes.
Equivalent provision.
Equivalent.
Okay. It is ordered in an interim that further proceedings of PSC number so and so shall remain suspended till a returnable date.
15-9,
To the-
15-9.
How long?
All right. Time being matter, item 4.
Itu kena go remember. That's a timing you ask. Huh? Yes. Time is over now.
Yes, sir. Kindly attend the matter and
Someday else. Next week, someday else. Mr.
A. Sarkar.
A.H. Sarkar and R. Kaushik. Next week or
Okay. Applies.
Tuesday or Wednesday. Yes. Anything?
Appeal letter admission are already asked.
Appeal.
Appeal already co-accused, their appeal has been admitted for other 4 accused convicts. This is for 8-2 lordship. Similar orders will lordship
Item number
12 lordship.
12. No?
I have this copies earlier, appeal copy. Yes.
Period of conviction.
341, 326, 307 for 10 years, 326 and 307. If other 4 accused, these are
Yes,
the 4
K.
accused
Poddar.
convicts.
S.K.
And
Poddar.
today 8-2 lordship.
Same conviction. Same.
Same judgment.
Same लिखी दिया S.K. Poddar.
Same date may kindly be both the appeal.
S.K. Poddar, same date.
Apply.
Yes. 13 to give us. Council is there.
Item 13.
No one is here, madam.
Not there.
Not there.
That hearing case, old case. What is
20.
it?
25.
25. It will give us a date. Tuesday did it could dictation है रिवर्स है. Put it at 3 p.m. Tuesday.
Lordship is
All
sitting-
case.
Yes, my lord.
That hearing.
Lordship is sitting again today.
No, I don't think so. Is there anything?
No, my lord. Not
Is it there? Well, neither switch. Okay, it is there. It is there. So we'll sit.
Madam.
I did not know.
No, madam.
Key hooligan, key hooligan. কি কৰি দিলে সুধি কেনে পঢ়িব এতিয়া পঢ়িব বুলি কৈছা পঢ়িব লাগিব ৰ'ব হ'ব বুলি
See, 5 point has been raised, 5 points
Oh, I forgot.
regarding
Perhaps.
52A.
Uh,
In this case, Lordship was satisfied.
Let me look at my note.
Chart जो 5 point जो है.
Code board.
Independent intelligence है, 52 वाला.
29.
Umbrella alert. Board, board.
Huh? ये something very eager. Right, अपन को नीचे.
52 वाला.
देखो ये वाला table है.
52 पेज जाओ. कौन सा पेज नंबर बोलो? डॉक्यूमेंट को जो लिखा है. अरे वो पेपर वो कर दिया. वो जो लिखा है 52 तक नहीं.
पहले तुम्हारे नहीं सब होता.
एक लिखा था.
They come to understand or even photo pattern, but you're right.
You but
Develop one page.
the major. Yes, one is regarding charge.
Yes, Lordship, regarding 17C.
Second is 313.
313, 52 and independent witness.
Then 52A.
And another point was raised by Lordship, point out that 313 statement was recorded. Earlier it was recorded, there was no question, answer was recorded. Thereafter again it was recorded. On the day when
Judgment was.
judgment was put.
Then lastly 32B.
32, yes.
Independent witnesses not examined.
Not examined. So regarding 52 and independent, will probably Lordship is convinced that after Ambala's judgment, the situation has been changed, Lord. Now let's see,
Situation is not changed, somewhat diluted.
Yes, diluted.
Some to an extent diluted.
Here in this case, Lordship, the substance was seized from the accused persons. It was produced before the court, and at the time of hearing, it was also produced before the court in bulk quantity.
It is basically para 50, Roman 5. Mere non-compliance of the procedure under section 52A or the standing order rules thereunder will not be fatal to the trial unless there are discrepancies in the physical evidence.
Yes.
Rendering the prosecution's case doubtful, which may not have been there or had such compliance been done. Court should take a holistic and cumulative view
Cumulative.
of the discrepancies that may exist in the evidence adduced by the prosecution and appreciate the same more carefully, keeping in mind the procedural lapses.
Yes.
This is the.
Yes.
But if raise the point by the side, then it is their duty to satisfy that.
No, you take your seat.
Should I address your lordship on 52A?
Hmm?
Lordship may come to PW1. PW1 is FSL expert lordship.
EW1. Yes.
PW1, he's Gajendranath Deka.
Yeah.
He was a FSL expert. He examined the samples lordship. In his chief, para 3, on the day I received parcel through director of DFA Assam in connection with NCB case number so and so for examination. The parcel consists of 7 exhibits.
Where is the date of seizure otherwise?
Lordship,
6/5.
Hmm. Okay.
Then parcel consists of 7 exhibits enclosed in a silk envelope cover. The facsimile of seal was found to be Narcotic Control Bureau. Then description of article is there. 6 sealed envelopes marked as S1, S2, S3, S4, S4, S5, S6, having 6 closed polythene packets, 1 packet in each envelope, containing 24 grams dark brown colored pasty substance each. The samples were again marked by me as DN 14316 to DN 14316 B respectively.
It should be F, I think.
Okay.
Because 6, next page. Okay, read it.
Yeah, then one seal envelope marked as S7 having closed polythene packet containing 5 grams of brown colored powder substance. The same was again marked by me as D. It is not visible 14316 G. Then next page, result of the examination. I have examined the samples mentioned above as per United Nations Drug Testing Laboratory Manual. The exhibit DN number so and so gave positive test for opium and percentage of the morphine in.
Wrong, that is wrong. Morphine, it should be opium.
No, lordship, there are 2 packets were there.
Read.
First is exhibit DN number so and so gave positive test for opium and the percentage of morphine in each. Yes, lordship, there is some. The next exhibit 143G gave positive test for morphine. And percentage of morphine in the exhibit was found to be 77.81. The report was forwarded to the Zonal Director NCB by the Director Mr. K.C. Sharma. Exhibit 1 is my report. Exhibit 1 by 1 is my signature. Exhibit 2 is forwarding letter, wherein Exhibit 2 is signature of so and so.
Where is that exhibit 1 otherwise? Part of paper book?
Yeah, lordship, fine.
154.
Yes, 154.
Yes.
Description is same laws.
Yes.
Then cross examination lordship. Page 3A. I have not verified the signature of any person on the sealed envelope containing the samples. I have not seen remand of the samples before or today. I have not narrated the procedure of examination in my report, but I followed the procedure laid down by the United Nations Drug Testing Laboratory Manual. Cross-examination by Saurabh Khan and Ram Milan. I have not mentioned regarding signature of any person or on the envelope containing samples of exhibit 2. This was the cross-examination. Nothing has been put to contradict him also. Then let's see, PW2 is the godown in charge, Ulika Moran. The samples were deposited in the godown.
Yes.
So we come to page 5, paragraph 1 to 3.
Yes.
I was also in charge of NC godown and on 7/5/2016 at about 5:45 PM, Sri Praveen Vaishnai, seizure officer, came to me along with the seized items and samples of the drug seized. He handed over those samples and article to me, and as the godown in charge, I kept all these items, samples in godown of the NCB and issue godown receipt through Sri Pawan Vaishnai. So the contraband were seized and submitted in a godown, that was admitted. But if I have gone through the cross also, but nothing has been, no question has been put to contradict her. Let's see, cross starts at page 6.
Yes.
Let's see, page 7. Paragraph 2. In exhibit 5 to exhibit 7, I received 6 seal packets marked as P1 to P6 containing 10.8 kg, 10.10 kg, 10.7 kg, and 3.8 kg opium respectively. Then exhibit 5 to 7 also I received the seal packet marked as P7 containing 2.05 kg of morphine. Then next, in exhibit 7, the facsimile of the seal is absent. Then let's see, question was put, I put my signature only on the first page of the compliance report submitted by Pawan Vaishnai under section 57 of the NDPS Act. Then I did not receive any extra forwarding letter with report under section 57 NDPS Act. It is not a fact that I did not receive any information on 6/5/2016. It is also not a fact. On 7/5/2016 in the morning, the accused persons were arrested. It is not a fact that all the suggestions were denied. Then let's see page 8, cross examination on behalf of Abdul Kalam and Mujibur Rahman. Let's see below 2 questions in page 8. Exhibit 5 to 7 are computer printed copy. 5 to 7 are the original godown receipts. Then page 9, they want to discredit the witness but could not. In exhibit 9, the report under section 57 of NDPS Act was not produced before the CGM before submitting to me. It is not a fact that exhibit 9 report under section 57 of NDPS Act was not prepared in time. We did not produce before CGM, and ultimately at the time of filing of the offense report, we tagged the offense report. It is not a fact that the accused Abdul Kalam and Mujibur Rahman were not involved in the present case, and they were arrested from somewhere else and falsely implicated in the case. So this was the cross-examination of PW2. Next week. Then let's see PW3. There was a Praveen Vaishnai. page 12, Lordship. Paragraph 1. During body search of the 4 persons and their belongings, provisions of section 100 CRPC were followed. Before conducting body search, I served the notice and section 50 of the NDPS Act to all the 4 persons. They acknowledged the same and gave the written consent of the body search. So section 50 was followed, Lords. Then Lordship, Exhibit 14, 15, 16 are the consent letter of the accused persons. Then below page 12, on opening the plastic bags carried in both hands by the accused Saurabh Khan, dark brown color sticky materials was found packed in 2 packets wrapped by brown color cellotape and kept in white polythene packet. A small quantity of dark brown colored sticky material was taken out from both the packets that tested with the help of drug detection kit brought by the NCB team, and both materials gave positive of the opium. Both the while plastic bags were marked as C1 and C2, and packet containing dark brown colored sticky materials were marked as P1 and P2 on weight with the help of the digital weighting machine in presence of the 2 independent witnesses and 4 suspected persons, and weight of P1 to P2 was found to be 10.128 kg gross and 10.14 kg gross respectively. The opium was seized in presence of the 2 independent witnesses, and 4 accused persons drew 1 samples in duplicate in 24 grams each and marked as S1 and D1, S2 and D2 respectively. All the 4 samples were duly packed in polythene and then kept inside the envelope. All the samples and seized dark brown colored sticky materials suspect to be opium was sealed with NCB brass seal number 1 and properly labeled, and signature of the independent witness and the accused persons and seizing officers were also taken on them. Then the polythene bags carried by Mujibur Rahman. Lordship, then the description how the goods were seized from different accused persons. Then Lordship may come to page 16. First paragraph. Both the vehicles, that is truck and Scorpio, were searched, and on search of the Scorpio, we found that a special cavity has been made and the vehicle number WB58C 2157. On inquiry, the accused Saurabh Khan admitted that the vehicle number so-and-so is registered in his name. He also told that he has made this special cavity for trafficking of drugs. Then the said Scorpio was seized, and on inquiry it was told by one Mujibur Rahman that truck number so-and-so was registered in his name. He also told that he brought the said consignment of opium and morphine from Imphal in this said truck, and the said truck was seized, and copy of the insurance premium slip of truck number so-and-so issued by United Insurance Company Limited and public carrier permit issued by the Transport Authority Thoubal against the vehicle number so-and-so were also seized. On inquiry, all 4 accused persons admitted their involvement in trafficking of the drugs. They also revealed that they were doing illegal trafficking of morphine and opium for last many years for monetary benefit. Therefore, on reasonable belief, as the offence has been committed under section 8C of NDPS Act as amended and punishable under section 21C, 17C, 29 of NDPS Act, the entire consignment believed to be opium and morphine was seized under section 43 NDPS Act 1985. Then page 17. The search cum seizure list and the Panchnama were prepared on the spot. The seize process was completed at around 12 p.m. on 7/5/2016 in presence of independent witness and accused persons. Exhibit 18 is the search cum seizure list and dated 7/5/2016. Exhibit 18(1) is my signature. The search cum seizure list was prepared in presence of independent witness and 4 accused persons Exhibit 18-2 is the signature of the accused Saurabh Khan. 18-3 is the signature of accused Mujibur Rahman. 18-4 is the signature of accused Abdul Kalam. And exhibit 18-5 is the signature of Ram Milan. Exhibit 19 is the Panchnama dated 7/5/2016. Exhibit 19-1 to 19-11 are my signature, which was prepared by me in presence of witnesses and 4 accused persons. After that, the notice under section 67 of NDPS Act was issued to the 4 accused persons on 7/5/2016. Exhibit 20, 21, 22, 23 are the copy of the notice under section 67 of the NDPS Act to 4 accused persons. Notice under section 67 of the NDPS Act were issued them for regarding the voluntary statement of the accused persons. Then voluntary statement was recorded. Your Lordship, page 19 is important. After recording their voluntary statement of 4 accused persons, I arrested them in contravention of provision of 8C of NDPS Act and punishable under section 21C, 17C, 29 of NDPS Act. Exhibit 28, 29, 30, 31 are the copy of memorandum of arrest issued to Saurabh Khan, Mujibur Rahman, Ram Milan, and Abdul Kalam in connection with NCB crime number so and so. After that, we returned to the NCB office along with the seized articles and 2 vehicles to NCB office and 4 persons. I deposited the seized articles P1, P2, P7, seized by sample number S1 to S7 and D1 to D7 and currency of rupees 17,000 to godown. The godown in charge issued same with acknowledgement. Exhibit 5 is the godown receipt number 1. Exhibit 5 on a signature of Tulika Moran, godown in charge. She is a PW2. Thereafter, on 8/5/2016, the seized articles and contraband was taken out from the godown for production in the court. I have received the godown receipt number 2. Exhibit 6 is the godown receipt number 2, where exhibit 6(1) is my signature on 8/5/2016. After production of the seized contraband and articles, I have deposited the seized articles and contraband to godown. The godown in charge, Tulika Moran, received the articles and contraband and acknowledged the same with receipt number 3 dated 8/5/2016. Exhibit 7 is the godown receipt number 3 dated 8/5/2016, where exhibit 7(1) is the signature of Tulika Moran, godown in charge. The next page, Lordship, page 20. Exhibit 8 is the godown receipt number 4. I have received the samples number 1 to 7 for sending the same to SFL. So it is corroborating with the evidence of PW1 lots. I have received the samples S1 to S7 for sending same to the SFL. I have received the samples. Exhibit 8(1) is my signature. Exhibit 32 is the test memo. Exhibit 32(1) is my signature. Exhibit 33 is the receipt of the office of the FSL Kalipara. Exhibit 9 is the compliance report, and Exhibit 67 of the NDPS Act is connection with NCB crime number 4 of 2016. Exhibit 9(1) is my signature. 9(2) is the signature of Tulika Moran. I know her signature. Then Exhibit 33 is the inventory, and exhibit under section 52A of NDPS Act, wherein Exhibit 33 to 33(4) are my signature. On 8/5/2016, I produced the seized opium and morphine and documents and 4 accused persons to the Judicial Magistrate, Kamrup, Guwahati on 8/5/2016. On Exhibit 34 is the prayer for judicial custody of the 4 accused persons in connection with NCB crime number so and so for recovery of 54.6 kg of opium and 2.60 kg of morphine in my and Exhibit 34 in my signature. I requested prayer was made with to CGM Kamrup Metropolitan Guwahati to allow the seized vehicles bearing number so and so in the custody. Then material exhibits were produced before the court. page 21. I have seized the articles with the samples have been produced before the court. Material exhibit 1 is the dark brown sticky materials marked as P1, which contain 10 kgs. Then lordship description is there, medical, lordship probably. Material exhibited were lordship up to page 24. Page 25 lordship cross of PW3. Lordship, I've gone through the cross, but I didn't find any contradiction. No question was put to specifically, lordship. However, some questions they tried to discredit the evidence, PW3, but could not succeed. In page 27, it is not a fact that I did not give, not that the search and seizure memo was prepared in presence of the accused persons, but there is not that they put their signature. Then next, insert and the search and seizure memo, I did not mention that immediately after the search and seizure, the seized contraband were wrapped with white marking cloth and label were pasted. I did not prepare the separate weight sheet of the seized materials. I did not prepare any seized sketch map for the place of occurrence where search and seizure was conducted. Then in exhibit 33, I showed the color of exhibits as the deep brown color. So with respect to color, lordship, they want to bring on record that the color was different, but probably that will not make any contradiction, lordship, in my humble submission. In Panchnama exhibit 19, I mentioned that the color of the seized contraband is dark brown color. I did not mention in exhibit 33 that is the inventory, the mode of packing of the contraband, making or any specific mark in the packet. I did not file any application before the magistrate for certifying the correctness of the inventory so prepared by me. In exhibit 6, the godown receipt number 6, 7, and 8, there is no mention of depositing the plastic bag in the godown along with the contraband packed. The memo number which is mentioned on the sample packets was not mentioned in the test memo. The witness added, it is not required as it is an enclosure. I explained the provision of section 67 of NDPS Act to the accused persons before recording their statement. I did not give it in my handwriting that before recording the statement of the accused persons under section 67 NDPS Act, I explained the provision of the provision to them. In exhibit 25 and 26, there is no mention of the case number in which the statement was recorded. I did not inquire the qualification of the accused persons before recording the statement under section 67 NDPS Act. The statement was written by the accused persons themselves, namely Mujibur Rahman, Abdul Kalam in my presence, but it was not written in English. The statement were voluntarily written by accused persons themselves, and I cannot say why they did not write in their mother tongue or language. So this is the cross-examination also. So page 21 is the further cross-examination on behalf of Saurabh Khan and Ramvilan. Let's say we come to directly to page 33. Second paragraph. It is not a fact that I proceeded this case in a defective way, without following the procedure laid down in NDPS Act and the CRPC. It is not a fact that there was no independent witness of Exhibit 18, search and seizure. It is not a fact that the case is manipulated for the purpose of getting promotion or other from the superior officer. The learned counsel for the accused persons, Saurabh Khan and Milan, has submitted a prayer for opening of the sealed packet of the contraband in the open court. Had the learned counsel for the parties, prayer is allowed. Material Exhibit 1, marked as P1, at the time of seizing contraband 10.8 kg of opium is found in sealed condition. The packet is covered with white marking cloth and label pasted over the same. It was found into the proper seal condition. After opening the packet, it is found that there is a dark brown sticky substance inside packet. Material Exhibit 1, marked as P1. The seized items contained 10.8 kg has been opened in the open court in presence of the accused persons and the lawyer of both the sides. After opening the said packet, it was found that there is a dark brown sticky substance inside the packet. Firstly, packet was wrapped with the brown color sheet, and thereafter it was covered with the marking cloth. It was found before opening. It is a properly sealed condition, and the label was pasted rightly. Another packet of the seized contraband marked P4 containing 10.12 kg, Material Exhibit 4, has been opened in open court in presence of the lawyer of both the sides and accused persons. The same was found in proper sealed condition, and label was pasted over the covered packet and opened for the accused Ram Milan. After opening the same, it is found that there is a sticky brown colored substance inside packet. It also appears that the packet was firstly wrapped with the brown paper, and thereafter it was wrapped with the marking cloth. So everything was Lordship, the sample were opened in front of the accused person in their advocate's room, at the request of the accused itself. So nothing contrary was found. So the purpose of section 52A, that the sample which were certified before the magistrate, where this would not be manipulated, Lordship. So here, Lordship, evidence of PW1 to PW3 clearly demonstrate that they were properly seized, packed, and they were opened before the novel court also, Lordship. So there is no question of any violation of section 52A. Yes, it is correct, Lordship. It was the sample were not certified before the land magistrate. But Lordship, this is optional. You submit, you will get your chance.
Don't interrupt.
So Lordship is seen, the evidence is how the samples were collected, how we will produce before the court. So there was no manipulation in between, Lordship. The sample were collected and they were sent to the FSA. And the corroboration is there with the evidence of PW3 and PW1 laws. Okay. So Lordship, the Bharat Ambale, Lordship has already gone through that judgment. Paragraph 50, Lordship, summary, how section 52 is to be taken into consideration. Supreme Court has elaborately discussed in this case. For benefit of my Lordship, I want to read again Lordship paragraph 50. We summarize our final conclusions under. Although section 52 is a primary for the disposal and destruction of the seized contraband in a safe manner, yet it extends beyond the immediate context of the drug disposal, as it serves the broader purpose of also introducing procedural safeguard in the treatment of narcotic substance inasmuch as it provides for the preparation of inventory, taking photographs of the seized substance and drawing samples therefrom in presence and with the certification of the magistrate. Mere drawing of samples in presence of the gazetted officer would not constitute sufficient compliance of the mandate under section 52A of subsection 2 of NDPS Act. 2. Although there is no mandate that the drawing of samples from the seized substance must take place at the time of seizure as held in the Mohanlal Supra, yet we are of the opinion that the process of intervening, photographing and drawing samples of seized substance shall as far as possible take place in presence of the accused, although the same may not be done at the very spot of the seizure. 3. Any inventory, photographs or samples of seized substance prepared in substantial compliance of the procedure prescribed under section 52A of NDPS Act and the rules standing orders thereunder would have to be mandatorily treated as primary evidence as per section 52A subsection 4 of NDPS Act, irrespective of whether the substance is in original is actually produced before the court or not. 4. The procedure prescribed by standing order rule in term of section 52A of the NDPS Act is the only intended to guide the officer and to see that a fair procedure is adopted by the officer in charge of investigation, and as such, what is required is substantial compliance of the procedure laid therein. Then 5. Mere non-compliance of procedure under section 52A or standing order rules thereunder will be not a fatal to the trial unless there is discrepancy in the physical evidence rendering the prosecution's case doubtful, which may not have been there had such compliance been done. Court should take a holistic and cumulative view of discrepancies that may exist in the evidence adduced by the prosecution and appreciate the same carefully, keeping in mind the procedural lapses. Number 6, if the other materials or record adduced by the prosecution, oral or documentary inspires confidence and satisfies the court as regard the recovery as well as the conscious position of the contraband from the accused persons, then even such case, the court can without hesitation proceeds to hold that the accused guilty, notwithstanding any procedure defect in section 52A of the NDPS Act. 7. Non-compliance or delayed compliance of the said provision or rules thereunder may lead to court to draw an adverse inference against the prosecution. However, no hard and fast rule can be laid down as to when such inference may be drawn, and it will all depend on the peculiar facts and circumstances of each case. Where there has been lapse on the part of the police in either following the procedure laid down under section 52A of NDPS Act or the prosecution in proving the same, it will not be appropriate for the court to resort to statutory presumption of commission of an offence from the possession of illicit materials under section 52 of NDPS Act, 54 of NDPS Act, unless the court is otherwise satisfied as regard the seizure and recovery of such materials from the accused persons from other materials or records. 9. The initial burden will lie on the accused to the first lay the foundation to show that there was non-compliance of section 52A either by leading evidence of its own or by relying upon the evidence of the prosecution, and the standard required would be only be preponderance of probabilities. 10. Once the fundamental facts laid indicate non-compliance of section 52A NDPS Act, the onus would therefore thereafter be on the prosecution to prove the consent evidence that either 1. There was substantial compliance with the mandate of section 52A of the NDPS Act, or certify the court that such non-compliance does not affect the case against the accused, and standard proof required would be beyond a reasonable doubt. So let's see, the case of the prosecution falls under clause 5 onward laws. And interestingly, Lordship, the accused laid evidence, but they could not bring on form to discredit the witnesses of the prosecution. So in my humble submission, even if Lordship hold that there was a non-compliance of section 52, but no prejudice has been caused, all the formalities were observed by the prosecution agency while seizing the materials and keeping godowns and sending to the FSL for examining. So let's see, regarding 52A, my humble submission is that Lordship, there was sufficient compliance was there, although it was not certified by my state, but all the prosecution has been taken in due care while seizing and sampling the samples. Lordship. Lordship, next point was independent witness. Lordship, there are so many judgments of Honorable Supreme Court where said that there is no hard and fast rule to examine the witnesses. But Lordship is to see whether the prosecution has taken sufficient care or steps to bring the independent witness known. I've checked up the record, Lordship, many times summons where even warrant was issued, but nobody turned up. So Lordship, I'm relying on one judgment of Honorable Supreme Court, that is 2018, 13 SCC page 808, paragraph 6. The printout of is from Supreme today, Lordship, not from SCC. Paragraph 6, Lord. Very Lord.
Yes.
Paragraph 6. We have considered the matter and have heard the learned counsel for the party. So far as examination of independent witnesses in support of the prosecution case is concerned, all that would be necessary to say that in this regard is that the examination of independent witness is not inadmissible, indispensable requirement, and such non-examination is not necessarily fatal to the prosecution case. In the present case, the accused case, according to the prosecution, independent witnesses were not available to the witness of recovery of contraband due to extreme cold. The fact of the incident took place at around 6:30 p.m. on 27/1/2009, and that too on the Manila Kulu Road, and lent credence to the prosecution version of its inability to produce independent witness in the absence of any immunity between the police party and the accused, and having regard to the large quantity of contraband that was recovered, we are of the view that unlikely that the contraband had been hosted in the vehicle of the accused person. Insofar as the condition of the contraband parcel is concerned, the materials on record indicates that the said parcels were brought to the learned trial court in torn condition. The prosecution witness examined in this regard and testified that the parcel was in torn condition due to its bulky nature and also due to nail on the stool of the which was kept. In this regard, it may be also be noted that the samples from the contraband parcels were sent to the forensic laboratory on so-and-so.
It is a case where seizure was made, there was no.
There was no witness. At all, there
There
was
is
no
a
witness.
case where seizure.
Witness was
Witness was there, but they did not come to the court to give their
witness
testimony.
was. Even
This
Lordship,
fact is different.
but Lordship, it is, our case is better than this case also. For this purpose, I want to write this judgment. Lordship, in view of the above, we are of the opinion that ground for which the High Court has reversed the finding of the conviction of the accused respondent ought not to be accepted. So Lordship, our case is more better than this judgment, Lordship. Yet there was no independent witness was there. Besides this, Lordship, there are so many judgments where if the prosecution witness are sufficient and confide the confidence of this honorable court, then Lordship can rely on the other witnesses also. Only Lordship is to see whether the prosecution has taken proper steps or not to call them to the witness box. Okay. Now Lordship, charge under section 17C. Lordship may come to page 145 of the judgment passed by the learned trial court. Paragraph 82. Married Lordship. The charge framed by my learned predecessor is under. First, on 7/5/2016, at Indira Gandhi Stadium at Sarsojai, you were found illegally possessing 54.68 kgs of opium and 2.060 kgs of morphine, wrapped by brown color sellotape with a commercial quantity without any valid document, and thereby committed offense under section 8C and punishable under 21C of the NDPS Act within my cognizance. Second, on the same day, the same time and the same place, all of you were inspired in furtherance of your common intention and thereby committed an offense punishable under section 29 of NDPS Act and with my cognizance or the cognizance of the Court of Session, but not framing charge under section 17C of the NDPS Act has not caused any prejudice to the accused persons, as the accused know for what offense they have been tried and charged framed under section 21C of the NDPS Act in terms of opium and morphine have been mentioned. Paragraph 84. Further, the learned counsel for the accused neither argued nor stated in their written argument that non-framing of charge under section 17C of the NDPS Act caused any prejudice to the accused person. Therefore, the same is an error, and in view of the provision of section 215 CRPC, the same is not material, as the accused was not misled by the error or omission, and the same has not occasioned failure of justice, and the accused know that they have been tried for possessing opium and morphine in contravention of provision of NDPS Act, section 215 CRPC read as under. Then 215, effect of errors. No error in stating either the offense or the particulars required to be stated in the charge, and no omission to state the offense or those particulars shall be regarded as any stage of the case materials unless accused was in fact misled by such error or omission in the and it has occasioned failure of justice. Then Lordship, paragraph 85, there is an explanation by the learned trial court. Therefore, I refrain from framing fresh charge under section 17C of NDPS Act at the time of writing judgment, and as the same will not cause delay in disposal and will cause delay in disposal of the case. Further, even it is held that non-framing of charge under section 17C of the NDPS Act has misled the accused, and the same has also occasioned failure of justice, the same will have no bearing on the outcome of the case, as the prosecution has been able to bring charge under section 1721C of NDPS Act against the accused person beyond all reasonable doubt, and the punishment for commission of the offense under section 70C and 21C of the Act are exactly same, and in the instant case, the accused have committed both offenses in one transaction. Both the sentence shall have to run concurrently. Then 86, it is stated that notification specifying the sample and quantity of the commercial quantity in NDPS Act, serial number 92, more than 250 grams of morphine is mentioned, and commercial quantity, and in the instant case, quantity of the morphine is used 2.60 kgs, which is much more than commercial quantity. And paragraph 87. Therefore, the accused Saurabh Khan, Abdul Kalam, Mujibur Rahman, Ram Milan were possessing the seized opium and morphine without any document in contravention of provision of section 8 of the NDPS Act and guilty of the offense punishable under section 17C, 21C of the said Act. In the result, from the facts, circumstances of the case and above discussion, I hold that the prosecution has succeeded in bringing home the charge under section 21C and 70C of the NDPS Act against the accused Abdul Kalam, Mujibur Rahman, Saurabh Khan, and Ram Milan beyond all reasonable. Hence, I hold that the accused Abdul Kalam and Mujibur Rahman and Muhammad Khan, Saraf Khan and Ram Villain guilty of offence under section 21C and 17C of the NDPS Act and convict them under the said section of law. In view of the discussion made above, there is no necessity of convicting the accused persons under section 29C of the NDPS Act. The point are decided accordingly. So this is the discussion, Lordship. There is no the offence committed under section 70C and 21C is same, Lordship. And as observed by the learned trial court, it proceed concurrently, Lordship. So even if the charge under notes 17.6 is not framed, it is not material effect. As observed by the learned trial court, the defense has failed to, they have not raised this point before the learned trial court also. So whether they can raise this point at this stage, recently, in case of Director of Revenue Intelligence and Rajkumar Arora, in paragraph, I'm sorry, Lordship, I could not make out the copies. I'll supply copy, Lordship. In this case, Lordship, scope of section 216 was discussed. I'm slowly reading, Lordship. Paragraph 142, section 216 of CRPC has been paragraph 14. Under the provision, any court is empowered to alter or aid any charge framed against the accused at any time before judgment is pronounced. Therefore, an outer limit is set, that is, the power conferred upon the court cannot be exercised after decision is pronounced in the matter. Although the provision does not expressly provide for stage of the trial after which the power under section 216 of CRPC can be exercised. Yet the logic and rationale obviously required is to be exercised after charge has been framed by the trial court under section 228 of the CRPC. For if no charge has been framed, there arises no occasion to add or alter. As a natural corollary, if the accused has already been discharged under section 227, no application under or action under section 216 would be maintainable. Paragraph 144. The court may alter or add any charge either upon its own motion or an application by the parties concerned. Therefore, such power can be invoked by the court suo motu as well. This power under section 216 is exclusively to the concerned court, and no party can seek such an addition or alteration of charge as matter of right by filing an application. It would be the trial court which must decide whether the proper charge has been framed or not at the appropriate stage of the trial. On consideration of the broad probabilities of the case, the total effect of evidence and documents adduced, the trial court must satisfy itself that the exercise of power under section 216 is necessary. The provision has been enacted with a salutary object to ensure fair and full trial of the accused persons. So, Lordship, the trial court has given a sufficient explanation and court has invoked section 215 of the CRPC. And this power is there, Lordship. This is a judgment pronounced on 17/4/2025 in case of NDPS also. In this case, the point was that if in schedule, if the drug is mentioned, if it is not mentioned in the explanation, then whether it can be taken into consideration. After discussing, even the purpose of the act was also discussed in this judgment. It's a long judgment, consists of paragraph 165. All aspects of the NDPS Act has been discussed in this. I'll place the copy of Lordship. But Lordship, just before few minutes, I find out the judgment. So under section 17C, Lordship, this is my explanation. Then Lordship, now a question was raised with regard to section statement recorded of the accused person under section 313. Lordship, it was demonstrated, probably it was fallen from your Lordship now, that when initially in 2018, the statement of accused persons was recorded, but out of 5 accused, the answer of the 4 persons were not there in the statement. Thereafter, the learned trial court passed an order and it was recorded and the same day judgment was pronounced. Lordship, here I have submission. Lordship may come to First, Lordship, I want to draw your Lordship's attention to page 97 of judgment, paragraph 28. The trial placed before Lordship and demonstrated how the statement was recorded, how it was considered, Lordship. Paragraph 28. Page 97, Lordship, of the paper book.
Yes.
In their examination under section 313 CRPC, the accused have denied the prosecution case and stated the allegations leveled against them are false and baseless. The accused, Mohammad Sarab Khan, has taken the plea that he was apprehended in front of the Hotel Fortune, Paltan Bazar, and was forced to write some documents and put some signature under threat. His signature were taken on blank paper. He is innocent, and he was also mercilessly beaten up. He also examined 2 witnesses to prove the same, but did not examine himself as a witness. Now, Lordship, P13 statement company. P13 statement also there. Lordship, we come to page 48. The first statement recorded, page 48, Lordship. The statement of Mujibur Rahman. That first recorded on 13/7/2018. Lordship, questions were there, but answers were missing. Then Lordship, we come to page 52. Question number 18.
Yes.
Question number 19, page 52. What do you have to say regarding the case against you? I came to ISBT by bus, and from there I was picked up. I was subjected to torture and thereafter compelled to put my signature on some blank papers. Then question 20. Do you want to examine any witness in defense? No. Now, Lordship, this statement was recorded on 22nd April 2019. Page 54. His name is Mujibur Rahman. Here he has denied. His answer is denied, not true, not known, false evidence. Then question number 18. Same as I read out to your Lordship.
Question number?
Question number 18 and 19.
Which page?
Page 58.
Okay.
Same, it was, this time it was typed. I came to ISBT by bus. From there, I was picked up. I was subject to torture and thereafter compelled to put my signature on some blank papers. Do you want to examine any witness in defense? No. As stated by him on 37/2018, same thing was repeated on 22nd April 2019.
Page?
Page 58. Now, Lordship, next accused person, Abdul Kalam. Same thing happened to him. No answer was recorded by that London trial court on 13/7/2018. Then question number 18. His person is that in the original, when the answer was missing. In 18, it is written by the London trial court. I came to Guwahati for treatment. I was lifted from Hotel Reach, Paltan Bazar, I was subjected to torture and forced to write some papers in their dictation and also forced to signature on blank paper. I am innocent and falsely implicated in the case. Do you want to examine any witness? No. Now, Lordship, on 22nd April 2019, his statement was again recorded. Same thing, same question. In other question, answer to other questions, Lordship, he has said this is false or false evidence not known. But in question number 18, he has given explanation as stated earlier, Lordship. Page 69. Page 69, question number 18. I came to Guwahati for treatment. I was lifted from Hotel Reeds, Paltan Bazar. I was subject to torture and forced to write on some papers on their dictation and also forced to sign the blank paper. I am innocent. I falsely implicated in this case. Do you want to examine any witness? No. Next page, page 70 is the accused Ram Milan. Same thing happened. Lordship, no answer is there, but in question number 18, he stated page 74. Question number 18. What do you have to say regarding the case against you? I was captured from outside the railway station of Paltan Bazar. I came here to see the Kamakhya temple, and I was asked there to give false deposition against me as I denied to do. I was taken into a jeep and was taken to a room and kept confined. Do you want to examine any witness? No. This was happened on 13/7/2018. Now, Lordship, page 76. The statement was again recorded on 22nd April 2019. Same thing, Lordship, either he said that not true, not known, false evidence. But with regard to question number 18, same thing has been narrated by him. Then in question 18, Lordship, same. And question 20, do you examine any witness? No. Now, Lordship, may come to evidence of accused number 4, Saurabh Khan. It was recorded in 13/7. Here, Lordship, his answer was also recorded. Lordship, please to note down that date, because also it is important to note how the case proceeded. And the doubt raised that on the same day, judgment was pronounced. Probably, Lordship, it will falsify all this after going through the 313 statement of Saurabh Khan. It was recorded in 13/7/2018. Against all questions, Lordship, answer has been written, either false, totally false. I don't know, but question number 18, Lordship. Page 85.
Yes.
Do you have to say regarding this case? I was apprehended in front of the Hotel Fortune, Paltan Bazar. I was forced to write some documents and put some signature under threat. Signatures were taken on the blank papers. I am innocent. I was also beaten mercilessly. Then question number 19. Do you want to examine witness in defense? Yes. Lordship, thereafter 2 witnesses were examined. Page 44. DW1 Ahmad Khan on the prayer of Saurabh Khan Lords. Statement were recorded on 2nd of February 2019, much before judgment was pronounced. My learned friend has already read out the evidence of DW1 and 2. Nothing has come out. Again, I'm for the benefit of me, Lordship, I'm reading again. Very small. Page 44. I have appeared in the court on receipt of summons. I know the accused, Saurabh Khan. I used to work under him at Dakhlabanda on 6/5/2016. I came to Guwahati to work under the accused and went to the Hotel Fortune near mosque at Palran Bazaar at around 7 or 8 p.m. to meet him. While I was waiting for him in front of the hotel, the accused persons came out, but as soon as he reached the gate, 4 or 5 persons apprehended him. Thereafter, many people gathered there, and the same person took him away in a Bolero vehicle. At the time of arrest, the accused person was not carrying anything in his hand. I tried to talk with him. The persons who had apprehended the accused persons, they did not talk to me. I came to Guwahati on 6/5/2016 by a rail traveling in general compartment. I have not brought the railway ticket to prove the same. I did not remember the phone number of the accused. And he said that he is acquainted to him as working under him. It is not a fact that the accused is my relative, and to save him, I deposed falsely. It is not a fact that the accused was not arrested in front of the Hotel Fortune. It is not a fact that the accused was not arrested in any presence. Lordship, my question for the moment, Lordship, he was arrested at the spot near the Guwahati, and they put their signature on the documents, Lordship. The story they have hooked up thereafter, it's not believable at all. The person who has deposed in his favor, he has failed to divulge the phone number of the person, and how he come to Guwahati, the ticket is not there. Then PW2 is Hiranya Soikia, page 46. I have appeared today as the Paltan Bazaar police informed me over telephone that I have been summoned by court to adduce evidence in the case from 8 July 2018 to 31st July 2019. I was working at the Hotel Fortune, Paltan Bazaar as general manager. I have brought Exhibit 1, 3 seats, guest registration card of the hotel. Exhibit 1 is not filled up properly, as there are many blank spaces. The checkout time and date is not mentioned in Exhibit A. The photocopy of the voter ID card includes with Exhibit 1 is one of Saurabh Khan. The photo state copy of voter ID enclosed with Exhibit 1 of Saurabh Khan was photocopied from original voter ID card produced by him at the time of taking the room rent. In the hotel invoice enclosed with Exhibit 1, the departure time is mentioned as 6/5/2016 at 9:20. Why we did not have separate register of guests as we enter everything about guest in computer. We preserve the CCTV footage at the hotel for 1 month. I do not know anything about seizure made by the investigating officer. No cross was done by the prosecution. When there was nothing to cross examine. So Lordship has seen that the section 313 statement, Saurabh Khan on 39/2018, Lordship, we stated that I want to, Lordship knows that after completion of the evidence of the prosecution, accused were examined. Yes, here Lordship, some defect was there because their answer was not recorded, but it was 2018. But in Lordship, defense witness was examined as per the statement of Saurabh Khan. And his statement was recorded properly. And Lordship, the prosecution and the defense has failed to produce, but to submit anything that what prejudice has been caused if they were subsequently they were examined and following the rules and others. So in humble submission, Lordship, it will not prejudice the accused person in any. Now, Lordship, section 32B. One second. One second. Lordship, in case, in support of my contention, Lordship, regarding what 313, Lordship, may take note of one judgment pronounced by the Honorable Supreme Court, reported in 2019 legal SC 150. Lordship, this, again, this is not a printout of SCC, Lordship, although it was reported in SCC also. 2023 SCC page 321. Paragraph 11, 12, 13, 14 and 18. Three. Paragraph 11. The paramount consideration being to interpret the law so that it operates fairly. The fact of the case did not show any need of visualizing with all the exception must be carried out to carved out and provide for. The attention of the court was also not invited to the need for considering the carving out exception. Individual right of the accused are undoubtedly important, but equally important is the social interest for bringing the offenders to book and for system to send the right message to all in the society. Be it the law-abiding citizen of the or the potential offender. Human rights are not only of the accused, but extend apart also the victim, the symbolic members of the society as potential victim and the society as a whole. Then paragraph 13. Law has to cater to wider variety of situation and appear in society. Law being dynamic, the certainty of the legislature appears rigid at the time whenever a circumstances set of the facts appears which is not catered by explicitity. Expediency then dictates that the higher judiciary, while interpreting the law, consider such exceptions as are called for without disturbing the pith and substance and the original intent of the legislature. This is required primarily for the region to help the strike a balance between competing force, justice being the end and also because process of fresh legislation would take a long time, which would mean fear of justice and with it erosion of public confidence and trust in the justice delivery system. The principle of fair trial now informs and energies many areas of the law. It is a constant ongoing evaluation process, continually adopting itself or changing circumstances and endeavoring to meet the exigency of the situation, peculiar in time and related to the nature of crime, persons involved directly or operating from behind, and so many other powerful factors which may come in the way of administration of criminal justice. Wherefore, the endeavor of the higher courts while interpreting the law is strike the right balance. Then paragraph 18, Lordship. The criminal justice delivery system cannot be allowed to veer exclusively to benefit of the offender, making it undirectional exercise. A proper administration of the criminal justice delivery system therefore requires balancing the right of the accused and the prosecution. That the law laid down in Mohanlal is not allowed to become springboard for acquittal in prosecution prior to same, irrespective of all other consideration. We therefore hold that all the pending criminal prosecutions, trial and appeals prior to the law laid down the Mohanlal shall continue to be governed by individual facts of the case. So Lordship, here I tried to place before a Lordship that the statement under section 313 were recorded earlier, and on that basis, Lordship, they produced their witnesses. However, there were some defects that was queued on the same day, and Lordship, the questions put to them were same, answers were in except 18 and 19. 4 accused said that they don't want to lead in evidence. But one accused said that he want to lead evidence, he led evidence accordingly, that was recorded previously. And in conclusion, what Lordship, no prejudice has been caused if the statement were recorded subsequently and judgment was pronounced the same day. Lordship, now question arises regarding 32B. Lordship, recently Supreme Court Narayan Das है ना कॉपी कर लो मेरा कॉपी तीन कॉपी है ना और कौन recently Supreme Court interpreting section 32 it's in case of Narayan Das and state of Chhattisgarh was pronounced on 17 July 2025.
NDBS is. NDBS.
Yes, yes. Let's see, paragraph 15, 17 and 19. Let's say we come to paragraph 12 or not. Probably it will be better to paragraph 22, 32B has been quoted, Lordship.
Yes.
We come to paragraph 13.
14.
13, 13, Lordship. Page 6.
Hmm.
While interpreting section 32B of the NDPS Act, the High Court also looked into decision of this court in the case of Rafiq Qureshi versus NCB reported in 2019 SIC to SCC 492. According to the High Court, at the time of imposing sentence, the trial court need to keep in mind the factors as provided under clause A to F of section 32B of the respectively. We are afraid the understanding of the High Court, it is not correct. Section 32B provides that court in addition to various relevant factors may also take into account the factors prescribed in clause A to F. Therefore, in given case, the trial court may not find it necessary to consider the factors as prescribed in section 32B. Having regard to the quantity of the contraband, the nature of the narcotic or substitutic substance, as the case may be, the incidents, if any, etc., may deem fit to impose punishment, which can be more than the minimum. In such circumstances, there was no good reason for the High Court to reduce the sentence from 12 years to 10 years, relying on Rafiq Qureshi. The dictum as laid down in Rafiq Qureshi has not been understood in its true perspective. Paragraph 16. In Rafiq Qureshi, this court observed as follows. Well, section 32B is also inserted by Act of 19 of 2001. It is useful to refer to the statement of object and reason for amendment of section Act 9 of 2001, which is
para? 19.
Paragraph 16. And statement of object and reason. The amendment of section Act 9 of 2001, the Narcotics, Drugs and Substitute Substance Act 1985 provides deterrent punishment for various offences relating to illicit trafficking of narcotic drug and substitute substance. Most of the offence invite uniform punishment for minimum 10 years, rigorous imprisonment, which may extend to 20 years. While the Act emphasizes severe punishment for drug trafficking, it emphasizes a reformative approach towards addicts. In view of the general delay in trial, it has been found that the addicts prefer not to invoke the provisions of the Act. The strict bail provisions under the Act add to their misery. Therefore, it is proposed to rationalize the sentence structure so as to ensure while drug trafficking, who traffics the significant quantity of drugs are punished with deterrent sentences. The addict and those who commit less serious offense are sentenced to less severe punishment. This requires rationalization of the sentence structure provided under the Act. It is also proposed to restrict the application of the strict bail provision of these offences who indulge in serious offences. Paragraph 13. The statement of object and reason reveals that the Amendment Act has inserted provisions for rationalization of the sentence structure. Section 32B is a provision which is brought in the statute to rationalize the sentence structure. Section 32B from clause A to F enumerates various factors for imposing punishment higher than the minimum term of the imprisonment. The submission made by the counsel for the appellant is that unless in the facts of the case, any of the factors mentioned in clause A to F are not present, the court cannot impose punishment higher than the minimum term of the punishment, imprisonment. It is submitted that the factors have to be brought in statute for the purpose of imposing punishment higher than the minimum. Hence, in the absence of any such factors, only minimum punishment should be awarded. We have to first see the actual words used in the statute to find out the object and purpose of insertion of section 32B. The court, after conviction of an accused, hears the accused and takes into consideration the different circumstances of the accused and the offences for awarding the appropriate sentence. Section 32B uses the phrase, the court may, in addition to such factors as it may deem fit, take into account the following factors for imposing punishment higher than the minimum term of the imprisonment. The above statutory scheme clearly indicates the following. 15.1. The court may, where minimum term of punishment is prescribed, to take into consideration such factors as it deem fit for imposing the punishment higher than the minimum term of the imprisonment or fine. In addition, take into account the factors for imposing punishment higher than the minimum as enumerated in clause A to F. The statutory scheme indicates that the decision to impose punishment higher than the minimum is not confined to or limited to the factors enumerated in clause 1 A to F. The court's discretion to consider such factors as it may fit is not taken away the incurred. In case of persons is found in possession of manufactured drugs whose quantity is equivalent to commercial quantity, the punishment as per section 21C has to be not less than 10 years, which may be extended to 20 years. But suppose the quantity of manufactured drug is 20 times of the commercial quantity, it may be the relevant factors for imposing punishment higher than the minimum. Thus, quantity of substance which is an accused is charged is a relevant factor, which can also be taken into consideration while fixing the minimum punishment. Clauses 1 to F as enumerated in section 32B do not enumerate any factors regarding quantity of substance as a factor for determining the punishment. In the event the court takes into consideration the magnitude of the quantity with regard to which an accused is convicted, the said factor is relevant factor and the court cannot be said to have committed any error when taking into consideration any such factor higher than the minimum term of punishment is awarded. This court, in case of Sakshi versus Union of India, reported in 2004 SCC criminal so held that it is well settled principle that the intention of the legislature is primarily to be gathered from the language used, which means that the attention should be paid to what has been said and also to what not had been said. A construction which requires for its support, addition or substitution of words to be avoided. In paragraph 19 of the judgment of the following was laid down. It is well settled principle that the intention of the legislature is primarily to the gathered from the language used, which means that the attention should be paid to what has been said as also to what has not been said. As a consequence of a construction which requires for its support, addition or substitution or words for which the results in rejection words as meaningless has to be avoided. It is contrary to all rules of construction to read words into an act unless it is absolutely necessary to do so. Similarly, it is wrong and dangerous to propose or substituting some other words for words of the statute. It is equally well settled that the statute enacting an offense or imposing penalty is strictly constituted. The fact that the enactment is a penal provision in itself a reason for hesitating before ascribing to phrase used in meaning broader than they would ordinarily bear. Then paragraph 18, the specific word used in section 32B that court may, in addition to such factors as it may deem fit necessary, clearly indicates that the court's discretion to take such factor as it may deem fit in not fettered by factors which are enumerated in clause A to F of section 32B. The learned counsel for the appellant has relied on a judgment of Allahabad High Court in Raj Kumar Bajpayee versus Union of India. Paragraph 39. After going through the impugned judgment and order very carefully, I find that the trial court, while imposing higher than the minimum punishment prescribed under the NDPS Act on conviction under section 8/20 of the NDPS Act upon the appellant has failed even to adhere to the factors enumerated in section 32B of the NDPS Act. In fact, no reason whatever is forthcoming in the impugned judgment which lead to trial court to impose higher than minimum punishment prescribed under the Act. After going through the evidence on record, I am satisfied that in present case, none of the factors as laid out in section 32B of the Act exist, which could have been prompted the trial court to award higher than the minimum punishment prescribed under the Act. The sentence awarded to the appellant thus cannot be sustained while maintaining the conviction of the appellant under section 8/20. I allow this appeal in part and modify the sentence awarded to them in trial court by imposing impugned judgment and order the 10 years RI and fine of rupees 1 lakh. In default payment of the fine, the appellant shall be able to undergo simple imprisonment for 1 month. And so, paragraph 20. Although the above judgment, it has been categorically held that the punishment higher than the minimum cannot be awarded unless any of the factors spelled out in section 32B are present. But the court proceeded to set aside the award of the higher punishment on the above grounds. There is 2 other judgments of the learned single judge of the Allahabad High Court which have been brought to our notice. First is the judgment of the single judge in Krishna Murari Pal versus Union of India, where that learned single judge in paragraph 13 has considered section 32B in the following word. The trial court has awarded the sentence of 12 years rigorous imprisonment and fine of rupees 1 lakh to the appellant accused under section 8B B2C of the NDPS Act on the ground that the huge quantity of the aforesaid contraband has been recovered from the possession of the appellant accused. There is nothing on the record to show that the appellant accused has committed any act which may lie under any of the clauses of section 32B of the NDPS Act herein above mentioned. But that does not mean that the court cannot award the sentence more than the minimum sentence in absence of any of the above conditions mentioned in clause A to F, because these conditions are in addition to the factors as court may deem fit in awarding higher punishment to the accused. In the case in hand, there is nothing on the record to show that the appellant accused has previously criminal history or has a previous conviction, and that the appellant is now advanced in years and is as of 56 years as mentioned in the supplementary affidavit filed on behalf of the appellant accused. Undisputedly, the appellant accused has license of the dealer shop of Bhang. Thus regard being at all the factors in circumstance of the case, I think that the reduction of sentence 12 years regards the imprisonment awarded to the appellant to the period of imprisonment already undergone him in the default of the payment fine. Reduction of the sentence of 1 year imprisonment of 6 months, simple imprisonment would meet the end of justice. Another case which has been relied by the counsel in case of Ramasre versus so-and-so. The following observation made in opinion of this court, if the said section be read with the greater attention, it would be revealed that the words used in it are, it may be deemed fit. Therefore, word may would indicate that it would be discretionary, discretion of the court to take ground into consideration which are mentioned in clause, subclause, subsection A to F of the said section, while awarding punishment higher than the minimum prescribed. Therefore, there is no force found in the argument of this, in this regard, made by the learned amicus curiae, that in case on hand, the punishment awarded needs to be curtailed, keeping in view of the lower court did not take into consideration the above facts. In view expressed by the learned single judge in case Murari versus State of UP, reported in so and so, paragraph 23. In view of the foregoing discussion, we are of the view that the punishment awarded by the trial court of a sentence higher than the minimum relying on the quantity of substance cannot be faulted, even though the court had not awarded to the factors mentioned in clause A to F as enumerated under section 32B. However, when taking any factor into consideration other than the factors enumerated in section 32B A to F, the court imposes punishment higher than the minimum punishment sentence. It can be examined by higher court as to whether factors taken into consideration by the court is relevant factors or not. Thus, in a case where the court imposes a punishment higher than the minimum relying on irrelevant factors and no other factors enumerated in section 32B to F is present, award sentence higher than the minimum can be interfered with. Paragraph 17. The seminal issue of in Rafiq Qureshi revolved around the interpretation of section 32B of the NDPS Act. In other words, whether the absence of any factors enumerated in section 32B clause A to F restrict the trial court from imposing sentence higher than the minimum prescribed. This court in Rafiq Qureshi clarified that the language of section 32B inherently reserves the court's discretion to consider other relevant factors beyond those listed. Specifically, the quantity of narcotic substance was deemed to be a pertinent factor warranting a sentence above the statutory minimum despite the absence of any enumerated aggravating factors in section 32B. Referring to Sakshi versus Union of India, this court emphasizes that the principle that legislature intend to derive from the explicit language of the statute, avoiding the insertion of the word not present, since section 32B uses may deem fit in addition to enumerated factors. It does not restrict the court to only those factors but allow broader discussion in sentencing. Paragraph 18. We may also refer to decision of this court in Gaurav Singh versus State of Punjab, reported in 2021 6 SCC page 558. In the said case, it was held that the court should be guided by the factors mentioned in section 32B of the NDPS Act and other relevant factors while imposing sentence higher than the minimum. Therefore, factors mentioned in section 32B of NDPS Act are in addition to other relevant factors, and it cannot be said that the minimum sentence under the NDPS Act is to be constituted as a maximum sentence. It is observed at page 564. Therefore, while imposing a punishment higher than the minimum term of the imprisonment or an amount of fine, the court may take into account the factors enumerated in section 32B of the Act referred to hereinafter. However, it is required to be noted that the section 32B of the Act itself further provides that the court may, in addition to the such factors as it may deem fit, take into account the factors for imposing punishment higher than the minimum term of the imprisonment or amount of fine as mentioned in section 32B of the Act. Therefore, while imposing the punishment higher than the minimum term of the imprisonment or amount of fine, the court may take into account such factors as it may deem fit and proper, and also the factors enumerated mentioned in section 32B of the Act. Therefore, on fair reading of the section 32B, the Act, it cannot be said that while imposing a punishment higher than the minimum term of imprisonment or amount of fine, the court has to consider only those factors which are mentioned enumerated in section 32B of the Act. Therefore, the quantity of substance would fall into such factor as it may deem fit, and while exercising its discretion of imposing the sentence imprisonment higher than the minimum if the court has taken into consideration such factors of large public higher quantity of the substance. It cannot be said that the court has committed an error. The court has wide discretion to impose the sentence imprisonment ranging between 10 to 20 years. And while imposing such sentence imprisonment in addition, the court may also take into consideration other factors as enumerated in section 32B A to F. Therefore, while imposing a punishment higher than the minimum sentence, if the court has considered such factors, it may be deemed fit other than the factors enumerated in section 32B A to F. The High Court has the only consider whether such factor is a relevant factor or not. It appears that the understanding of the High Court, so far as section 32B of the NTPX is concerned, is that the minimum sentence should be considered as maximum sentence. This is not a correct understanding of 32B of the NTPS Act. Be as it may, we do not want to interfere with the part of the order of the High Court reducing the sentence. So Lordship, the purpose of section 32B, the Lordship, while imposing punishment, court can see the reasons enumerated in section 32B, the quantity involved in the present case. Here, Lordship, the quantity is much more than the quantity. For learned trial court, Lordship, while imposing sentence, learned trial court has observed paragraph page 147, paragraph 91. In paragraph 90, they stated, had the convict Muhammad Abdul Kalam, Mujibur Rahman, Saurabh Khan and Ram Milan on the question of sentence, they have pleaded leniency in avoiding the punishment on the ground that they are the first offenders and they are sole bread earner of the family. Paragraph 91. In the case of so-and-so, the Honorable Supreme Court has observed, it appears from the statement and object of the region of the amending Act 2001 that the intent of the legislature was to rationalize the sentence structure so as to ensure that while drug trafficking, who traffic in a significant quantity of drug are punished with deterrent sentence and reduce those who commit less serious sentence and sentenced to less severe punishment. Under the rationalized sentence structure, the punishment would be vary depending upon the quantity of offending material. Thus, we find that it is difficult to accept the argument advanced on behalf of the respondent that the rate of the purity of the irrelevant since any preparation which is more than the commercial quantity of 250 grams and content 0.2% of heroin or more would be punishable under section 21C of the Act. Because the intention of the legislature, it appears to us, is to levy punishment based on the content of the offending drugs in the mixture and not the weight of the maximum mixture as such. This may be tested on the following rationale supporting 4 grams of heroin is recovered from the accused. It would amount to a small quantity, but when it is same 4 grams is mixed with 50 grams of powdered sugar, it would be quantity or to be commercial quantity. In the mixture of the narcotic drug or psychotic substance with one of the more natural substance, the quantity of natural substance is not to be taken into consideration while determining the small quantity or commercial quantity of narcotic drug or psychotic substance is the only actual content of the weight so and so. The intention of the legislature for introducing the amendment is to appear so as to punish the people who commits less serious offense with less severe punishment and those who commit grave crimes such as trafficking in significant quantity with more severe punishment. In the instant case, the convicts are not petty drug traffickers as they were trafficking in significant quantity, which were much more than the commercial quantity. Further, we can see from the discussion made above, the accused Muhammad Mujibur Rahman and Muhammad Saurabh Khan are the registered owner of a seized Scorpio vehicle and the truck, but till date, they have not claimed the seized vehicles as there is no evidence that other than the trafficking in drugs, they have other source of income. Therefore, they must have acquired the said vehicle from the illegal gotten gain or the.
These are assumptions.
Lordship, this.
Area 92 is assumption.
So this is the thing, Lordship, the court has considered the quantity of the drug seized. So punishment was more than minimum punishment was, higher punishment was prescribed for them. That has been, Lordship, explained in the judgment of Narayan Das I placed before Allah. Under the circumstances.
This para 92 is
No, Lordship,
going
this is,
beyond something.
the London trial court has considered the quantity on the basis of the intention of the legislation. And regarding 32, we, Lordship, I placed the judgment which has clarified the situation. Lord. So in humble submission, Lordship, the appellant accused persons have failed to make out to interfere with the judgment on all the 5 grounds, Lordship, which has been there. No, no. So under the circumstance, Lordship, if Lordship required, I may be given opportunity if my landed friend wanted some other facts. Under the circumstance, Lordship. Lordship, please supply the copy of the judgment.
Yes.
Thanks.
Keep it short. I have heard, we have
Madam,
heard
already-
extensively, nothing more.
My lord, in this case, my learned friend has stated regarding the compliance of the section 52A. I don't think I explained on this, Lordship, already, Lordship, who him 4 times already heard from me, Lordship, regarding compliance, and Lordship judgment is also there for Lordship list of samples.
Okay.
List of samples that was not done, and as per Ambale also, if points raised by the prosecution defense, then it is their duty to establish that they have complied the formalities observed narrated in the section 52A. That has not been established. He has PW3, he himself stated that he has not complied with the, he has not filed any application for compliance of section 52A. So list of sample which has been drawn, that is not before the magistrate, and that is admitted in the Ambale also. So Lordship, even if it is produced before the court, in that case also Ambale has stated that in 3, any inventory photographs or samples in 50 summarized in 3, and any inventory photographs or samples of seized substance prepared in substantial compliance of the procedure prescribed under section 52A of the LPS Act and the rules that or standing orders thereunder would have to be mandatorily treated as primary evidence as per section 52A subsection 4 of the LPS Act, irrespective of whether substance in original is actually produced before the court or not. But this formality has not been complied with. In last also, it has, in 10 also, it has been stated.
Roman 5 is, it has been explained again.
Yes, yes,
Roman 5
Yes.
below
yes.
4 and 5.
That is where Lordship, on last occasion, Lordship stated that this is a double-edged sword. Both side, though it is in the favor of the accused also, as well as it is mentioned regarding the in favor of the prosecution also. Mere non-compliance of the procedure under section 52A or the standing order orders thereunder will not be fatal to the
So,
trial unless.
Other combinations are also to be looked into, other discrepancies in the prosecution case.
Yes, but Lordship, in the last, in 10, once fundamental facts laid down indicated non-compliance of section 52A of the NDPS Act, the onus would thereafter be on the prosecution to prove by cogent evidence that either there was substantial compliance with the mandate of section 52A of the Act or satisfy the court that such non-compliance does not affect in the case against the accused or standard of proof required would be beyond reasonable doubt. Those
Roman 10.
Roman 10. So they must have to prove that, Lordship. Then Lordship, I would like to make one submission regarding non-compliance of regarding alteration of SARS, 216 CRPC. Munu. Minor, kindly see the CRPC,
Yes.
section 216. Lordship, 1 and 2, any court may alter or add to any charge at any time before the judgment is pronounced. Every such alteration or addition shall be read and explained to the accused. So in our case, what happened, Lordship? Alteration under section 17 he has made, but that was not read out to the accused person, Lordship.
And what the court says?
Court says, Lordship, both are same, section 17 and 21 are same, punishment is same and same, Lordship. That is why he has altered the section, Lordship.
He
But
has resorted to 215.
2015.
215, but 216 is also that is shared.
No error in stating either the offense. That is one part. Or the particulars required to be stated in the charge. Now, particulars are so many cases of opium, so many cases of morphine under your possession. At least the charge initially framed contained those particulars, right? That so many cases of opium, and so many cases of morphine. These are there. So there are two parts to it. Either the offense, 21C or 17C,
Yes.
215,
Yes.
or the particulars required to be stated in the charge, and no omission to state the offense.
Yes, sir.
Or those particulars shall be regarded at any stage of the case as material unless the accused in fact misled by such error or omission and it has occasioned a failure of justice. So, opium, morphine, clear.
That is in the charge. Section of
Cases are also clear. How many cases? That has not changed. So, offense or particulars. Now we have to test 216 with 215.
216.
215 and 216.
16.
We both
Both.
have to see.
Lordship.
And that has been clarified in the judgment I produced before, Lordship.
There is another judgment also, if not Lordship comply 216 too, then this is one of the error, Lordship. Then
Then also 464.
464 is there, Lordship.
Ah.
464 is there.
No finding, sentence, or order by court of competent jurisdiction shall be deemed invalid merely on the ground that no charge was framed,
Yes, Lord.
or on the ground of any error, omission, or irregularity in the charge, including any misjoinder of charge, unless in the opinion of the court of appeal, we are appeal,
Yes, Lord.
a failure of justice has in fact occasioned the error. So failure of justice has to be occasioned. So 215, 216, 464, court of appeal, failure of justice. All these are factors to be looked into. But one thing stays constant, opium,
and
Morphine,
morphine.
so many cases, so many cases.
Yes.
Let us see the charts.
But 21,
Let us see the
Lord,
chart.
21 and 17.
That has not changed that on 7/5/2016 at Indira Gandhi Stadium, Horujai, you were found illegally possessing 54 point so many kgs of opium, 2 point so many kgs of morphine wrapped by brown color cello tape. It is clear.
Yes, Lord.
Particulars is clear.
Individual charge is not there. Individually, they have collected
Well-
all these things. Individual charge is not there.
Not there, but particulars are there.
Particulars are there. But Lordship, section 21C
Okay,
for
we'll look into it.
and 17 for opium,
We'll look into it.
Lordship. Then and regarding the independent witness, Lord,
Yes.
regarding independent witness, my learned friend has mentioned that
Yes, Manja.
someone issued warrant issued. Lordship, kindly, I have flag marked the lower court orders, Lordship. It is clearly mentioned on 9/7/9/2018.
They failed.
There is nothing, last chance was given,
They failed.
they failed,
Ah.
but there is no warrant, Lordship. Last chance
Okay,
was
what is
there.
the penalty?
Yes, since. Could,
These are facts.
yes, no
What is the
person,
consequence?
my lord, they have categorically, this is a case under an EPS Act, based, punishment is short stringent. So that is why
Show me any authority.
authority is there, Lordship.
Show me. On the other hand, you question that these are your stock witnesses.
Stock witnesses.
Had,
They are still,
had they been stock witnesses, they could have easily produced.
no, my lord, they are still working under them, Lordship. To our information, Lordship, out of the record.
Information of the record will not do.
Ready to do, independent witness.
What is in black and white, only that.
2017, 15 assist. And 22 did. Sanjit Kumar. Hello.
So paragraph 70 of judgment, page 139. The court had discussed about the independent witness of it.
139, yes.
With the permission of Lordship, my learned friends, that I am interpreting her.
No, I'm not interpreting. No, I'm not disturbing you at the
Don't-
time.
Something was pointed out, don't, this is not the place for doing that. Yes.
Paragraph 70, page 139.
What does it say?
Lordship, married lords. The learned counsel for the accused further argued that as the prosecution could not examine the independent witness, the prosecution
Okay,
case
I have marked that.
liable to be
It is
rejected.
there. I have,
It is.
My lord, in this case, paragraph 27. Twenty-nine. 20, 27, 29, and 11, 30, 33 and 33A.
yes.
It is mentioned that therefore, if the story advanced by PW7 is to be believed, he received the information. Paragraph 27, I'm reading, 27,
27.
27, 29,
27 you will read and 29.
29, Lord.
27, yes, 27.
And second one is he completed the formalities and sent.
That's it.
Yes, 27. He received the information at about 1650 hours. He completed the
different.
formalities and sent notices to the independent witness at 1710 hours. He left the police station at 1710 hours and reached the place of incident in 5-7 minutes. And his team waited at the place of the incident for 40 minutes for the accused to arrive. Then but in the above timeline, PW7 is completely silent about the time when witnesses reach the police station or place of incident. Exhibit C1 is the notice reportedly served on the independent witnesses. So and so and so. This notice directs the said witness to appear at 1710 hours at the place indicated therein, namely so and so and so. Even according to PW7, this notice to the witness was sent only at 1710 hours to be served at the residence of the witness located 1 kilometer away. Therefore, there was no way that PW7 could have expected the witness to be available at the place of incident at 1710 hours. Exhibit C2 is the notice served on the appellant herein A1 under section 50 regarding this 50 at the time shown therein is 18 hours. This notice requires the appellant to indicate whether he would like
No,
to be.
both of you have deviated from the subject.
My lord.
This is this judgment perhaps regarding
Here-
the possibility of the witnesses to arrive at the place of seizure. This try to understand.
Lordship.
Impossibility of the independent witnesses to arrive at the place of seizure.
Lordship.
And on the other hand, the judgment which has been relied by Mr. Kayal is that
No witness could present at the time of the seizure.
Huh?
Witness could not be due to cold.
Witness
Could not reach the, did not find the witnesses there.
did not find at the place of seizure.
Not so.
Here is a case
Here
that witnesses were there,
could not be
but
examined.
they could not be brought into the witness box.
Witness book.
None of this is relevant for the purpose. Directly on
Yes.
the point,
Yes,
not directly on the point.
My lord, come to paragraph number 34.
That every case is based on its facts. Have not you heard?
I don't.
Honorable Justice Thulia limiting his office, that one has to be the court of facts, thereafter judge of facts, then judge of law.
yes.
So first it is to be facts.
Indeed.
That observation will flow from this 27 and 29. Whatever is there.
My lord, in this case, no notice issued to the witnesses. And they have not proved that there is no.
That is not your argument. Don't broaden now. Don't broaden now. Question is non-examination of the independent witnesses in the witness box.
Yes, Lord.
That is the issue. Okay then.
My lord, kindly see the this judgment lordship.
That is why I said every decision is a decision on its own facts.
Yes.
My lord, 8. If any independent witness is available and the prosecution initially seeks to rely upon him, it cannot suddenly discard the witness because it finds him inconvenient and place reliance upon police witnesses only. In stringent nature of the provisions of the Act, the reverse burden of proof, the presumptions of culpability under Section 35 and the presumptions against the accused under Section 54, any reliance upon Section 114 of Evidence Act in facts of the present case can only be at the risk of a fair trial of the accused. So in Karamjit Singh is distinguishable on its facts as independent witness and
Madam,
refused to.
You have not understood my point.
I understood lordship, but exactly that in that point I
So
did not.
many days for so many days the hearing was going on.
Then my lord.
So it is a point argument definitely, but not backed by any authority.
My lord.
Not backed by any authority to bind us.
I find out one judgment, lordship, the copy is not with, me, but invoke it.
No,
is
no, no.
My lord.
Exactly the point.
Question is, independent witnesses were there, supposedly. Supposedly independent witnesses were there and also police witnesses, meaning they were NCB witnesses. So now two sets of witnesses. You would say that the NCB witnesses are interested witnesses.
Yes.
You would say. And independent witnesses are independent. Now, in the witness box, independent witnesses were missing, but police witnesses were there. They deposed. Right? So corroboration is required from independent witnesses. That might be your case, right?
Yes.
So here is a case that independent witnesses were not there.
Yes.
So
In
that
this
is
case-
what you said, right? That is your case.
That is my case. And my lord, in this case, one more thing is that 32 is not applicable in this case, and higher punishment why he has imposed that has been explained in the judgment. But before that, my learned friend, which judgment referred before this honorable court, regarding that, I would like to say, lordship, in that case, it is explained that 32 that 32B.
These witnesses, witnesses everything. Only two programs. Okay, we'll consider this.
32B, A to F, there are some conditions, lordship.
Yes, already we'll go through the judgments. These are exhaustive judgment on 32B.
Lordship.
We'll look into it.
But lordship, here, other factors also must have to consider, lordship, regarding antecedents and all.
We'll find whether there is still more holes
Yes.
or not. We'll look into the
Lordship.
judgments.
Lordship. Lordship.
It is an exhaustive judgment, both.
We have some judgments, so I will pass, lordship, I will.
Tell me,
we dared up-
Supreme Court judgment on 32B.
Lordship.
Supreme Court judgment.
Supreme Court judgment. Lordship, first time offenders, then it was reduced to this minimum sentence, lordship.
Okay, hand over.
Listen, take it up. 2018, 17, 18. Take it up. To 10 years and for sentence 6 months. The relevant considerations are available at para number 15 and 16. That is also we have, lordship. I hate to disown. 2013 judgment also I have submitted, lordship. It is clear that clause B of the section 1 of section 30 of the code authorizes the court to award the imprisonment in default of fine up to 1/4 of the term of imprisonment which the court is competent to inflict as punishment for the offense. However, considering the circumstances placed before us on behalf of the appellant accused, and they are very poor and have to maintain their family, it was their first offense, and if they fail to pay the amount of fine as per mentioned here's additional in addition to the period of substantive sentence, because their inability to pay fine, we are of the view that serious prejudice will be caused not only to them, but also to their family members who are innocent. We are therefore of the view that ends of justice would be made up if ordered that in default of the payment of fine rupees 1.5 lakhs, the appellant shall undergo RI for 6 months instead of 3 years by the additional sessions number for the reasons stated above. The AP is partly allowed, the conviction is confirmed and sentence imposed upon the appellants under undergo RI for 15 years is modified to 10 years. The order of payment fine of rupees 1.5 lakhs, it is
Okay. This in Pradeep Bachar, it has been mentioned.
yes.
In paragraph
Paragraph
3.
nine is not mentioned. In 2013, Azad Khan. It is provided before that the first time offenders and there is no past antecedents above their involvement in offense of like nature on earlier occasions. And 2005 also.
Yes. First time offender, are you disputing it?
Lordship, even the first time, and
No.
he may
Are
be,
you first time offender, yes or no?
no, that is there, Lordship, because
That is all.
in record that nothing is there that your previously.
Yes, based on a commercial quantity,
Yes.
definitely.
My point, Lord Narayan Das.
You have read the judgment.
Yes,
We
Lord,
have
that is,
looked into it.
In
that is-
Narandas also it is mentioned, Lordship.
No.
Antecedents.
that Allahabad High Court judgment was mentioned, but Supreme Court came to that, no, lower court has power to give punishment below than maximum time.
Any, if to find two on this side,
Yes,
two on
Lord.
the other side.
But Lordship, I have checked up, this is the judgment exclusively discussed with section 32B.
But what the High Court, yes, what the High Court holds, that has not been dismissed, Lordship, that has been not cancelled, Lordship.
Okay, we'll go through it, you know.
Yes, it is, request that is. And my lord, regarding the judgment placed by my learned friend, this big judgment, that is Lordship Rajkumar Arora. In this case, in paragraph number 46 and much upper than section regarding this, it start from 140, paragraph 142. It has been discussed in paragraph number 46. It may state 146. It is stated that Lordship the powers of the powers under section 216 was elaborated. It was stated that the power under these provisions to alter charge is an exclusive and wide-ranging power, and this is clear from the fact that it may be exercised at any time before the judgment is pronounced. Before the judgment, Lordship. And if meaning also stays where evidence and arguments are completed and the judgment is reserved. It was further that if the court is opinion that there are an omission in framing of charge, if the existence of the factual ingredients constituting another offense is also interfered from a prima facie examination of material brought on record, the alteration and addition can be done. Such material brought on record must have direct access with the ingredients of the LS. This court mentioned that the power under this provision must be exercised judiciously and observed as follows. Here discuss Lordship regarding to the 216. 216 is there, Lordship, already perused that. 216 2. It should be read over to the accused person if altered before judgment. But in our case, what happened, that though earlier it was read over, but
We have heard you for 4-5 days. We understand.
plus and
Ms.
3-1
Nargis,
plus
you don't have to repeat 5 times.
plus
Am I clear?
plus
Am I clear?
plus and 313 Lordship regarding 313
I have heard you for 5 days, I think.
Yes.
plus
don't stretch your submission to test our tolerance,
No, my lord,
please.
my lord.
Please. We have heard you enough. Is it not? My pages are full. Hey, no new submissions. So all are same. We have heard you on the points.
One last point, lordship. In seizure, there is no seizure of vehicles, lordship. What was used in this crime, lordship? That was not seized, and they have not proved where it has kept if seized.
So, Ms. Nargis, you should structure your submission before starting the hearing. Right? It is not kind of a loan, one loan, then thereafter top up. No. Those with you?
My lord, I'll place all the citation by compiling it right now.
Whatever you have given is given, only 2 maximum you give.
Regarding
Don't,
in relation to my submission, lord,
already I have noted your name in each judgment.
I'm giving that
Only
was I will not,
2 more maximum. Not
my
that.
lord, I will not repeat that.
Only 2 more if you want to give. Right? Heard Ms. S.K. Nargis, Narek Counsel for the accused appellants, Mr. S.C. Kal, Leonard. What do you say? Public prosecutor?
Special public.
Special Public Prosecutor, NCB, for the respondents. Arguments are heard. Judgment is reserved.
Much of.
No, go on, volume.